udah bakal dikit palingnya. Tidak mana sekedar tinggal sedekat. Jual dua. Karena tinggal tinggal.
taken up any day, Your Lordship, subject to your
Item
lordship.
54. For that matter, we had fixed.
Your Lordship had fixed it as within 1 to 10, but it's appearing in the group 6 heading as item second, Your Lordship.
Group 6, when it is taken up? Tomorrow. Tomorrow it will be taken.
Sincerely. Lordship, this matter was dismissed for default and it was heard by a coordinate bench and the matter was made returnable on 3rd of November. I have mentioned it thrice, Your Lordship. The urgency in the matter is that because there are criminal proceedings, so the Honorable Single Bench had stayed the departmental proceedings. The delinquent is to retire in some days, Your Lordship, and entire departmental proceedings will be stalled, has been stalled.
You are saying it was dismissed in default then?
During the COVID time, it was dismissed for default. We filed a restoration application.
That's done.
Your Lordship, before the coordinate bench, when the matter was taken up, the other side did not appear in spite of notice. So, a fresh notice direction were issued and the matter was made returnable on 3rd of November 2025.
Yes.
Your Lordship,
Before the other bench.
Now the determination has come before Your Lordship.
That restoration will come before us now.
Your Lordship has the directions. Determination.
Is it on the list?
Your Lordship, I have mentioned thrice, but it has not come in the list.
Why restoration is not coming? The restoration I allow immediately. Why it is not? What is the problem? Get it? Yes.
My lord, may I permitted to mention one modification application, Your Lordship. Earlier, my lord, I mentioned the matter before the Honorable Chief Justice T.S. Sivagnanam, as Your Lordship then was. My lord, take up the matter, directed the registry to place the matter before the bench having the determination of group 6 matter, Your Lordship. I have the order with me, Lordship.
Yes. What is the modification you want? Can 2 is the modification.
Yes, Your Lordship. Modification of the order passed by Honorable Justice Subroto Talukdar and Lopita Banerjee, my lords then was.
It will be included in the next monthly list.
Permitted to mention a matter for correction, Your Lordship, of a judgment dated 4/2/2026. Just one minor correction needed, Your Lordship. Mr. Ramchandra Guchet, who appears for state respondent, it was recorded as he appears for municipal corporation. Just one correction needed to be
To
included.
be mentioned tomorrow, day after, any day. Any day, tomorrow or day after.
Liberty to mention a matter, my lord.
Yes.
My lord, this matter is concerning a special leave petition whereby the Supreme Court has directed the High Court to reconsider the matter. My lord, kindly sees the order of the Supreme Court.
Yes. Let us see.
My lord, page 2, para 5. My lord, there was a rule which was not placed before the
Yes,
court.
before the apex court, you have said that due to inadvertence, you could not point out.
Yes, my lord.
So yes, then what is to be done? This is a disposed of matter.
Yes, my
So
lord.
rehearing.
Yes, my lord. For reconsideration.
And it was who has passed? This bench has passed the order.
No, my lord. My lord, this was passed by Justice I.P. Mukherjee and Justice Pratip Prakash Banerjee, my lord.
So it is of which group?
Group 6, my lord.
What is the date of this order?
My lord, the date of the order passed by the Supreme Court is 9th September 2025.
And you are mentioning in February,
My lord.
getting an order that it should be disposed of expeditiously, and you are mentioning in February. Include it in the next monthly list.
Obliged, my lord.
Come in the on the first, then you mention it will.
Obliged, my lord.
Hello, what?
For some correction. Which number? Look it over. Last line of the sixth paragraph. Last line of the sixth paragraph. This one. Should be CT. Look up. This matter is listed at the instant.
Number 2.
But I am appearing for the respondent in the review matter. Oh, petitioner in the review matter. My lord,
Make up your mind.
my lord, actually I am more used to appearing for the respondent. Now, my lord, I wanted time because it has come suddenly. Yesterday night I have not received an instruction from the Register 23 matter. Can you give me a 1 week time?
Then we'll proceed with the contempt.
My lord, 1 week time, then then my lord proceed with the, give me a 1 week time so that
Wish for the petitioner.
petitioner,
Petitioner in contempt application. I am.
Who you are there?
Yes, Lord.
my lord, kindly give me
What
1
is
week.
the review? What is the scan number?
There's a copy नहीं है,
What is the review?
Kindly give me 1 week time. I've not received any instructions from the department.
You have examined the defects. Have you examined the defects which have been pointed out?
I didn't have the copy of the review in my residential chamber. It is in my official's chamber. So it appeared suddenly in the list. But give me 1 week time so that I can take an instructions and be prepared and come before you, my lord. Let it come on 24th of February. I will, if the review doesn't stand, then my lord can proceed with the conference. Give me 1 week time, my lord. My petitioner, review matter at 216.
As prayed by the learned advocate.
দেখে নিবে তো আজকে টিফিনে আছে এখন দেখে নেবো।
Number 4 to 7.
427, madam, I'm appearing for the petition.
No, I am appearing in item number 5.
4, 6 and 7, madam, I'm appearing. You are appearing for? 4, 6 and 7. 4, 6 and 7. You are in 5.
I'm in 5. I was appearing in 4, 5 and 7, 4, 6 and 7. Yesterday, the client took a no objection.
Madam, the similar matter, your lawsuit fixed on 24. And I did. Out of 2, madam, your lawsuit fixed your lawsuit, madam, 24. Your lawsuit, madam, 20 minutes, 24. Give it back to me. Navoda. What happened in 5? Resolved.
No.
What happened?
My lord, there are 3 orders. First order says.
May I
order is
indicate one
complied
thing, my
with.
lord?
Yes.
First order says it's complied with. Second day, Lordship directed them to file an affidavit of compliance. In respect of item 5, that affidavit of compliance was not filed. There's a name mismatch.
Yes,
And on the
yes,
third
yeah.
day, my lord, the matter was adjourned.
Therefore, you need not say the entire thing. Therefore, we are asking, he had assured that it was being resolved. What
No.
happened after that? We are
My
asking.
lord, my lord, may I,
The appointment letter.
my lord, may I just say one thing, my lord? That
Yes.
only yesterday, my lord, the government had issued the document, my lord, And today, my lord, the DPSC will collect the same. And within this week, my lord, appointment letter approval has already been given by the government. My junior is there, my lord, to who have the document in his WhatsApp, my lord.
Get a printout. Get a printout. This is not the way. Give him a copy also, so that he will know that it is done. Get
So
a
then, my
printout.
lord, can you take about on Thursday, my lord? I will come up with everything, my lord, with the
And
appointment letter. I hopefully
what about the other four matters?
other three
Other
matters,
three
my lord,
matters.
they supposed to file exception, but on the last occasion, Mr. Banerjee said that his client doesn't give. Now he says that his client has taken no objection. I think, my lord, we have already complied the order, my lord. Lordship kindly seen, my lord, they are not come within the zone of consideration. That's what, my lord. Now they have come up with all this, please.
Yes, where is that stand that you had placed on record that they are not?
But I have filed my report, Lordship. Kindly go through the kindly send that report. 16% who have not come within the zone of consideration, they are less in numbers. The chart that I have filed on the last occasion, Lordship's view was that they have to take out an exception, but nothing they have done, my lord.
The report in the form of affidavit by
Lordship,
contender
Shilpa,
number 2,
it has been affirmed by Shilpa Nondi, the chairperson of the DPSC.
2nd December 25. Yes, this.
My lord, my lord.
এই যে খেতে হলে বোকাচোদা গিয়ে শুয়ে পড়বে না। So this is a common stand with respect to the other three persons, but you have given the marks of only one, 34.206.
That chart I have given, this 4% name is there, 3 has not come within the zone of consideration, and another person, my lord, whose name is, there is a mismatch in the name, and by this week, my lord, we will give him appointment.
What is the name of these three persons? S.K. Nazrul Islam. What is the name? Sopanora. Malik. And my lord, Sopanora. These three persons. Plan 75. Other Pandit. Other Pandit. And it to not only Sopanora. First one. With these three persons, they have got 35.356, 4.206, and 35.05. The cutoff mark, last cutoff marks is 38. And then keep it going.
Yes, we are not granting any time to you.
Kindly, my lord, your lordship, then my lord.
Heard. Yes, yes.
Only yesterday, my lord, the notes. I have
All right,
received, my lord,
take down. Heard the learned advocate for
My lord, just, my lord, I'm reading, my lord, for your lordship.
yes, please.
But 27, my lord. But I'm reading from my lord, paragraph 26. Appears to be fallacy in the submission of the respondent in this regard. The challenge is not made to the entire challenge prepared by the different parties respondent. Even candidates who have been placed in separate panels as plain candidates. Approached 11 candidates are adding as parties in the litigation as well as to understand and number happy that respondent number 560. The no plus they choose not to appear in the topic and therefore it cannot be said that they are not made party to the topic. Peter on the part of the court to proceed to decide the matter expertly against those 11 candidates who describe the service is not to defend or to say the contention of the respondent that all the candidates who have been shown in the panel and given an appointment has to be made party is unfounded in view of the limited scope of the application, but with the remedy or the relief which can be given to the applicants. We are not unmindful of the situation that the candidate who has been serving for more than a decade should not go out because of such irregularities having committed by the authorities, but equally we cannot overlook the enforceable right of the authorities, but enforceable right of the applicant who are deprived of that right in the hands of the executive. We are concerned that the Honorable Banerjee appointment of 11 candidates were challenged and court held that such appointment is not illegal. Simultaneously, the court directed the authorities to prepare the panel in terms of Rule 9 of the state rules, which appears to have misconstrued by the authority that no further action is required to be taken. The direction passed in the Honorable Banerjee is explicit and clear that the authorities were directed to prepare the panel on the merit-wise irrespective of the reserve categories and thereafter to proceed in accordance to appointed provision. Malad, the observation of the judicial bench, Malad, these laws were complied. Malad, then Malad, we therefore set aside the order carried by this petition was dismissed on the court at the moment. The appointment of the aforesaid 11 candidates are found to be illegal. No interference with legal is warranted. The aforesaid assist. Therefore, my lord, my humble submission, my lord, what my understanding will, my lord, the part of mark, my lord, is not correct.
Yes, take down. Heard the learned advocate for the
24.
Call the next.
Identical one.
Number 8.
For the petitioner, my lord.
I am heading for this statement.
Next is lordship. My lord. My lord, the main petition, my lord, in this honorable court, and this is for default. But what was the petition, my lord? This petition was, my lord, non-payment of subsistence allowance, working pay, group insurance, general provident fund, increment benefit of the fixation of day under ROPA. Now the whole question, my lord, now the writ petition is no longer in the, he has died, main writ petition. Now this present petition is, my lord, by the successors and heirs of that particular deceased employee, writ petitioner. My lord, kindly see, my lord, can number 3, I will start from can number 3. There are 4 can 1, 2, 3, 4. And first we start from the can number 3, that is the restoration of the entire writ petition. Can 3, my lord, restoration of the entire writ petition.
You had filed a reply before the tribunal.
Well, yes, there was the reply was filed.
Reply
But this copy.
পাইনি তো
No, tribunal.
না ট্রাইব্যুনাল কিন্তু আরেকটা পাইনি তো দেখি ট্রাইব্যুনাল পাইনি
It was a
ট্রাইব্যুনাল কমপ্লিট হয়ে গেছে
find out it's an old matter. You can have a look.
Very well.
Yes. Tribunal. See what we are. Where is the tribunal's order? Which page of which
my lord,
page of which?
knowledge, my lord, default, my lord, paragraph 7 of the can.
Where is order passed by the tribunal?
Tribunal.
Which page of which pleading?
Finish. That is, my lord, page 2, that is contempt petition, my lord, 48.
Contempt.
Contempt petition, kindly see the judgment which have given. Contempt petition, my lord.
This is WPST is for contempt.
Well, the
One
initially
minute,
it was taken up at the motion stage. Some order was passed. The department was directed to pay the admissible subsistence allowance since the deceased delinquent officer was placed under suspension. Now, such decision, I do not know whether it has been complied with or not, but my learned senior friend filed a contempt application alleging that such direction has not been complied. I shall ascertain, my lord, that whether this has been complied with or not.
Yes. Oh, so see, that was an interim order.
Yes, that
was an interim order.
Yes.
Today, the entire matter is before us.
Right.
We want to see what is the tribunal's direction. Let us see what the
Yes.
tribunal has decided.
OA was dismissed.
Can I see the
After conclusion of the disciplinary proceeding, the the delinquent employee was terminated from service, which was challenged before the tribunal. But tribunal, my lord, found that the finding of the inquiry officer and the finding of the disciplinary authority was in order, and my lord, his original application was dismissed. Challenging that dismissal order, my lord, this writ petition was.
yes. Kindly see.
So where is the order by which the interim direction was?
My lord, that is, my lordship will find in the contempt application. This is CPAN 376 of 2005.
28/6/2004.
My lord.
CPAN.
1 minute.
তারপরে আবার হাইকোর্ট একটা ডিরেকশন দিয়েছে। মানে 28 June 2004 at 24, my lord.
So in view of his dismissal, what he will get as a retirement due?
My lord, only his provident fund, my lord. Because
And
gratuity
group insurance?
group, no, my lord.
No,
No.
nothing.
Only provident fund.
Only provident fund.
Nothing has been given.
We know nothing has
Sorry,
been.
Maria,
We are asking you what is entitlement?
Yes, I am very sorry. I am very sorry.
Entitlement is only provident fund.
I am very sorry, my lord.
Only provident fund, or you're entitled to any other due?
I am very sorry, my lord.
No,
Only
what
provident
is your entitlement? What is your entitlement after dismissal?
Tribunal, my lord, page 24 of the we are trying, he is no longer there, he has died. We are praying for all the dues, non-payment of group is 1 minute, non-payment of subsidy allowance.
Sir,
Or-
we are asking you,
Subsidy
please,
allowance.
please, we are asking you, once he has been dismissed, what will you be entitled to? After dismissal, what all dues are paid apart from Provident Fund?
Part of subsidy allowance, group insurance, general provident fund.
Group insurance he should get.
Benefit or fixation of pay under ROPA 1991.
ROPA you will not.
4 things, my lord.
Well, subsistence allowance during suspension, one employee is entitled.
That is subject to what the order may be passed.
Yes,
If
yes,
he is
yes.
getting anything else, he will, otherwise he will not get.
Absolutely.
Yes.
Then he is entitled to receive provident fund.
His deposit in the Provident Fund.
Yes, yes.
Yes.
Now, gratuity he is not entitled to, no pension, no leave encashment. Now, group insurance, I shall ascertain, my lord, within a day.
Perhaps it may be, because it is a subscription based due, it may be. We are not very sure, but perhaps he would get the.
By today, my lord, I shall ascertain. Whether he's-
Anyway, so let's see the tribunal's order.
My lord, your lordship will find the in the writ petition, one of the last page, this is dated 28th August 2003. This was transferred from High Court.
Yes, August. Tribunal, 20th August 2003. Page copy, page. Page down. Page কত গো?
It's the last
Page-
page.
page দিয়েছেন নাই। Page দিয়েছেন করেন, হ্যাঁ। পেজও করে না কি বল 20th August 2003. কোনো মেজাজ নাই কোনো কি করব না এটা কত নম্বর এটা কত নম্বর হ্যাঁ and two. Content.
Yes. We have read the order. What is wrong with the order? Tell us. What is wrong with the tribunal's order?
My lord,
Yes.
what happened, my lord? With the tribunal, there is a main question whether tribunal has jurisdiction to deal with this type of case under section 15 of the West Bengal Service Rules 51. But the question, my lord, is the tribunal has been started for the benefit and welfare of the employees of the government and semi-government authorities. Here, my lord, kindly see, all the pensionary benefits have been withheld or has not been paid after his, though he was, my lord, found not guilty or no charges against him during suspension period has been proved. Therefore, it can be assumed that he was not ascertained or attached with the alleged corruption that has been made in the department, that hospital, regarding the accounts, etc., etc. So, my lord, here the learned tribunal, but in instance, he invoked jurisdiction of the tribunal, which is not permissible under 20 of the Administrative Tribunal Act. My lord, so for 20 is concerned, my lord, 20 is concerned, my lord, so far I remember, my lord, all types of, my lord, punishment, all types of punishment can be invoked, can be dealt with by the tribunal. But so for 20 is concerned, my lord, I think, subject to correction, there is also some cases laws also regarding this 20. What type of cases can be tried by the tribunal or can be refused the tribunal? My lord, kindly give one day time.
No. We
Yes,
have adjourned.
we have to go
We
through
have
what-
adjourned sufficient
but
number. What is your
without-
submission?
but with
Judgment will
consist-
come later. What is your submission? Let us see Administrative Tribunals
Yes.
Act. Cannot adjourn it every day, 2004 matter. Yes. Where is the Administrative Tribunals? Section 20 is exhaustion of remedies, perhaps. Section 20 is exhaustion of remedies.
Yes.
My lord,
Yes.
Perhaps.
Yes.
It is not dealing with
representation. Yes.
My lord,
21 says limitation and 20 says exhaustion of remedies.
My lord,
If a representation is filed, then 6
Within
months.
6 months, my lord, the authority will consider, otherwise he is at liberty to file a case.
And if an order is passed, then 1 year.
Yes.
my lord, 1 minute, my lord, 1 minute, my lord. Kindly see, my lord, application for contempt petition, that is WPS 2004, page 24, kindly see. Page 24 the contempt application. Kindly see, my lord.
Huh?
What is the observation?
What? Page?
That is contempt for the person. Contempt for the person.
Yes.
Kindly see, my lord, page 24 of the contempt application. Page 24 of the contempt application. May I read? Ability to oppose, yes, that is UPST 53 of 204.
Sir, what is wrong with the tribunal's order? We will come to the contempt later. What is wrong with the tribunal's order? Yes.
I am coming, my lord.
Yes.
The observation in the contempt application, ability to opposition be filed within 4 years, etc. With regard to the substance announced, the complaint of the complaint of the petitioner is that the entire substance allowance has not been paid to the petitioner, which he was entitled before the remuneration. The learned advocate for the respondent states that no such amount is lying due. In above view of the circumstances, Respondent 2 is directed to decide as to whether the petitioner is entitled to any amount of area of substance allowance. If any such amount is found due, the same may be paid within a period of 3 months. If no such amount is found due to the same may be committed to the petitioner. My lord, so far my instruction is concerned, my lord. So in this, no such, my lord, adverse order had been made either by the, my lord, that tribunal or my lord, while admitting the contempt application here, no such and my lord, adverse or my finding has been given. If so such amount is found, the same may be committed to the petitioner. With regard to the retirement benefits, the respondents are directed to pay any amount which may be admitted by the respondent as payable to the petitioner in accordance with the law, and such payment is to be made with the 3 months from the date. That is also observation of the learned and on this honorable court. Is on court, my lord. That is page 24 of the WPST 53 of 2004. A contempt application here. These honorable court also expressed their opinion about the payment of non-payment of certain amount of money at initial stage. Therefore, my lord, if there was any lacuna in the judgment of the particular tribunal, my lord, with due respect to our honorable court, my lord, this honorable court did not pass such order. So, my lord,
We are asked.
regarding 20, my lord, give me some time. I will also satisfy your.
No time.
No.
Today, no time. This is the
20
third adjournment. No time now.
20, I have not.
No time today, sir. Enough is enough. 3-4 times we have adjourned. No further adjournment. We will not. We will reject your prayer for an adjournment today.
Yes,
2004 matter. Restoration pending. 4 adjournments.
Satisfied lordship regarding 20 of
Do it right now. You read it right now. You read it slowly. We'll go slow. We'll not adjourn it. No adjournment.
Regarding 20, my lord.
Nothing, sir. You read 20.
Therefore, our High Court has been observed.
Forget about 20. We will consider. See your High Court what has observed. You have already read. We have seen it. We are asking you what is the infirmity in the tribunal's order. Come to the tribunal's order.
Yes.
What is wrong with the tribunal's order? No question of any adjournment now.
My lord, kindly. 1 minute, my lord. Yes, tribunal order, my lord, dated 20th 8.
Yes. Now what is bad? How the order is bad? Why it is bad?
My lord, on 8/2/95, the applicant was again placed on the suspension.
Don't read the entire order. Tell us what is wrong with the order.
In contemplation of trial of dismissal proceeding in terms of although the order is wrong, my lord, kindly see. 1 minute, my lord. And I will start from page 9, second paragraph.
Yes, please.
As regards charge number 1, the applicant admitted that he was directed through order number 241 decreto of the superintendent to look after the bills prepared by the Vishwanath Raj and sign them before placing to the superintendent. If the applicant had not checked the bill, it becomes a violation of superintendent's order and as disposed of by the other two accused. My question, my lord, whether it has been checked or not, that has not been proved by the in the tribunal. If the applicant, but my lord, grievance was that the applicant had not checked the bills, that is a question, but not. It becomes a violation of the superintendent order. Allegation against me that I have not checked the bills before passing. And as such, it was by other two accused. Original copies of the bill were prepared by the applicant himself. All bills bearing the applicant's signature at different places as a mark of the checking. The bills were prepared in this way not for a few months but for few years. The applicant played a leading role in the unlawful game of the impression in the bills. The inquiry officer authority clarifies the position by citing one instance like page 11 of the bill number 147 with reference to the acquittance role. Total of the basic pay at column 4 was originally rupees 36,000 odd, which was subsequently rewritten as 41,000 and odd. And the correction bears the signature of the applicant himself. This inflation along under basic pay had fetched rupees 5,000. As regards the charge number 2, the inquiry authority ascertained that applicant was entrusted with pay bills, taking of the said bills and putting his signature at relevant point and putting his signature at relevant point as a mark of taking. Here it was checked by the concerned authority. This is employee. Then to the superintendent DDO for final signature. The applicant caused inflated bills to be signed by the DDO for years together in a calculated manner. As the DDO put his final signature only after ensuring that the applicant's signature was available on the implement bills. Very important line, my resource. In bill number 423 dated 17/1/1989, pay of 110 DDS has been drawn. Basic pay of 15 employees from serial number 81 to 95 has been increased by rupees 1,000 per month each time. This inflation has been made in amounts payable to individuals. This allegation. A close look into the entries at page 9 to 10 of the bill in the acquittance roll shows that the one is thousands place have been entered at some subsequent stages after the disbursement was. It was clear to the naked eye that those ones were not put during preparation of the bill, but at a later stage, since these one were widely different in the handwriting style as well as from the other figures appearing in the bill. And so far, the evidence is concerned, my lord, I beg to differ on this point. The employees concerned have also denied in writing that they had received anything to excess. As regards charge number 3, misappropriation to pay bill number 129 dated 1994 and number 176 dated 27/8/199, rupees 15,000 rupees and rupees 30,000 have been respectively defalcated through the two bills in a similar manner as in charge 1. The applicant was maintaining the cash book under his own handwriting and signature, and the amounts drawn through the inflated bills were entered on the receipt side of the cash book. The entire amounts drawn were shown as disbursed on the payment side, leaving no disbursement cash in behind. So, my lord, in that it is questionable, my lord, observation of the learned tribunal that cash book is main cash book is maintained and reserved by the superintendent of the hospital. In the given background, we find that the three charges against the applicant in the departmental proceeding have been well established. His allegation of not getting the documents of reasonable opportunity of defense. My question, my lord, of defense or not getting the opportunity to cross-examine the witness, etc., are not quite made out. The applicant had the basic responsibility of observing the preparation checks and amendment of the tables by order number so and so of the superintendent, and he was responsible also for the maintenance of the cash book. The correction and alteration in the amounts of the bills were duly authenticated under his initial signature, and the review passed the bills. Arguably, after being satisfied that the signatures, initials of the applicant figured at the appropriate places and points. The points raised by the applicant in the written notes of the argument cannot be considered alone strong enough to lend support on his cause. In the given background, therefore, the prayer of the applicant fails to merit and the application is dismissed. My lord, if this particular restored, my lord, will get full opportunity to place our case. They were first, my lord, our prayer to your lordship to restore this application so that we may be given the opportunity to satisfy your lordship that my client, the petitioner here in my lord, was not, my lord, accused person, super accused concern, because he was, my lord, not given an opportunity of, my lord, examining the whole thing by his superior officers. So, my lord, this very important point, these points has raised by the applicant in the written notes of argument cannot be considered. My learned judge of the tribunal below, my lord, did not practically, my lord, has not been properly considered the entire thing and the records of the case maintained. But from the point of view, my lord, preliminary, my lord, they were removed from suspension. If the authority concerned was satisfied about the primarily that he was guilty, he cannot be removed from suspension. He was suspended all along, my lord. However, my lord, without any suspension, my lord, he has challenged his, my lord, this part, his case against him before the learned tribunal. So, my lord, I think, my lord, he is not in the service now. He's mentioned, my lord, he is retired from the service as he's crossed the serviceable age. So, my lord, my earnest prayer before lordship to consider his post-retirement, my lord, benefits, especially, my lord, his retired, his, my lord, widow, who has other no source of income. So, my lord, every family widow is, my lord, is dependent upon the pension, who are in the government service, dependent upon the family pension, my lord, of his retired husband. So, my lord, kindly see this question and kindly give, finally want the shortest date, my lord, I will satisfy the lordship regarding the section 20 of the tribunal.
No
Act.
adjournment today, sir.
Why not?
No adjournment today.
My lord, kindly, then regarding 20, my lord. My lord, in support of my case, my lord, in the case of S. Nagaraj for the state of Karnataka,
Yes, please give whatever judgment you like.
here, my lord, everything has been, my lord, discussed, starting from the. Also, this case is also contempt of court act, under contempt of court act. My lord, Article 137, Supreme Court rules, review, recalling or reviewing its own order for a court to remove error. That is, my lord, S. Nagarajan versus, is it proper citation? Citation? S. Nagarajan versus State of Karnataka. My lord, 1993. Can you see, my lord?
What is it that you're, what do you want us to see in that judgment?
It is Contempt of Court Act in 1996, Supreme Court Supplementary Supreme Court report, just like it.
What is that judgment for?
Judgment for, my lord,
Which point this judgment is supporting which point?
yes. And main point here, my lord, recalling of reviewing its own order, power of court to remove. Therefore, and my lord, page 2. My Article 14 and 16 of the Constitution of India scheme framed to help educated unemployed commendable rule which results in under benefit of one class to exclusion of another. Explanation by state government as amended, not challenged. Rules being not in consonance with the constitutional spirit. Any appointment made under these rules not open to challenge on ground that they are not in consonance with the constitutional spirit. Therefore, my lord, my almost all people lordship, that is, my further, my lord, page doesn't get copied in, no? Yes, and
What point you are trying to, what is the point you are arguing?
my lord,
This judgment is in support of which point?
point, my lord,
Yes.
next paragraph, my lord, next page 2. B. Constitution of India, Article 14 and 16 still seems to help educate and etc. Rule which results in undue benefits to one class to the exclusion of others permits only state civil service without compensation. Exploitation of state in violation of Article 39 as amended as though not challenge, rules being not in consonance with constitutional spirit. Any appointment made under these rules not open to challenge on ground that they are not in consonance with the constitutional. Here, my lord, my first point of submission to the lordship is that in 1977, the government of Karnataka framed a scheme for employment of unemployed graduates, postgraduates, and diploma holders with a view to relieve unemployed among them. The scheme was made applicable to persons coming from families having less than rupees 3,600 annual income and no earning member of the family. The stipend was raised finally to rupees 640 per month from rupees 150. After expiry of nearly 4.5 years, the government from Karnataka Civil Service recruitment 82, reserving 50% of the state of the direct recruitment vacancies existing on the date of the rules came into force, to be filled by stipendiary graduates and local candidates in various categories of the post, which included first and second division assistance in civil service by a competitive examination to be conducted by the Public Service Commission. These rules were amended at 87 and 3 important changes were made. 1. The rules become applicable to any category of post in Group C in the state civil services. 50% was bifurcated and 40% was reserved for stipendiary graduates and 10% for local candidates. And the requirement of examination or interview was done away with. The Association of Stipendiary Graduates filed a petition seeking declaration that they were regular employees under the rules. Their claim was not accepted by the tribunal as they having been appointed under a special scheme and not against any post in a cadre. They were not members of any state function. On regularization, it was held that it could be done by the state only and not by court. This order was challenged in the filing a CP. The state did not file any reply within time allowed in the court. The court passed an interim order directing the state to pay a stipend of ₹960 per month to the stipendiary graduates. The court directed the state to file affidavit regarding regularization and absorption of the employees, stating specifically in the total number of vacancies to be filled up and how many of those available to be filed up by the stipendiary graduates in accordance with law. These state tribunals that the number of stipendiary graduates required to be regularized was and vacancies in Group C were available for being filed by direct recruitment in accordance with the rules. No details were given to explain the distinction between first and second division assistant, nor any breakup of vacancies for first division and second division was mentioned. Based on this fact, The court passed an order 24 July directing the state honor to absorb all the stipendary graduates against the existing vacancies and create supernumerary posts for the court. Therefore, my lord, state has some power to make his own rule regarding the condition. The petitioners not satisfied made an attempt to succeed for further requirements in court and graduate in the order dated October. The government, after being apprised of the modified order without making any effort to get the doubt removed, issued a number of orders for implementing the order of this court by appointing and regularization of stipendary graduates as directed by the court. On 11 June, for the first time, letter was issued to contents of which were against the tenor of orders issued till then. In implementing orders of the court and absorbing the stipendary graduates in post-carrying graduates, in post-carrying graduates qualification, the government decided that absorption could be both against first division and second division assistants. However, the stipendary graduates were not agreeable to accept the post of lower division assistant in Group C as the minimum qualification for this was only SLP. The petitioner filed contempt application accusing the government of going back on its earlier order. A claim was made that the stipendary graduates should only be absorbed against posts which required minimum graduate qualification. The government issued an order stating that to avoid any discrimination, mark the point, and in view of the availability, the vacancy of the second division assistant cadre was considered appropriate to absorb these stipendary graduates only against the second division assistant post. Another order was passed on 5th September 1991, creating 5,000 stipendary posts. An affidavit was filed stating that 3,691 vacancies mentioned above earlier comprising the both in second division and first division assistant and not out of vacancies of the majority were of the second division assistant. The affidavit did not mention the earlier orders issued by the government. Considering the government was deliberately not obeying the words of the court without any valid explanation, this court passed an order dated 24 October directing the government to absorb all the stipendary graduates and first division assistants. An application was filed by the clarification of the order. In the affidavit, it was stated, since the court in every order had directed the stipendary graduates to be absorbed in accordance with the rules, it would have taken 10 to 15 years for the entire lot to enter in service. It was decided to create 5,000 supernumerary posts and absorb all the stipendary graduates as second division assistants. It was stated that only 3,300 posts of first division assistants were available. Administrative difficulties were also pointed out, and it was avowed for the first time the direction to absorb them at the level of first grade assistant would bring about a discrimination even as between the stipendary graduates. It was stated that objections had been received from second division assistants who had been selected by the Public Service Commission and had been working since 10 to 15% years, as they would be seriously affected if the claim of petitioner was accepted. It was claimed that the order dated 30th October 1991 was passed by the court on misrepresentation of the fact furnished by the petitioners. So, my lord, government order is always not was not provided by the Constitution. What the Constitution has provided, my lord, equal pay, equal pay as it was, then Article 14 and 16, my lord, frame, my lord, to help the educated unemployed person. Me, here also meant, my lord, no charges have been framed. I was, my lord, acquitted from all the charges. But why I should not get, my lord, the same benefit as other pensioners had of getting? If I was not acquitted, that's a separate question. But I was acquitted from all the charges. Even I have all the dues. And it was not observed by the my lord for a time, my lord, by the learned tribunal that government has not given me. Therefore, my lord, why the principle of equality will not be, my lord, applied in this case, my lord? I was not discharged. I was not, my lord, I was not discharged my service. Still I was, but I did not, without my lord getting any pension, post-pensionary benefits, my lord. That's why I had been at the, my lord, before the court, before the tribunal. So, my lord, this case has, my lord, much.
10 minutes later.
Now, finally, my lord, the application filed by the state government saying that the order did for observing all the stipendary graduate in pay scale to be recalled is allowed. All the stipendary graduates covered by the order did shall be appointed as second division assistants, etc. So, my lord, sometimes, my lord, government order may go against him, against employee, but Constitution has given my power, my lord, to your lordships to consider the case. My lord, if you lordship,
Where is the inquiry report?
these are also there, my lord.
Inquiry report, yes. My lord, the inquiry report is at page 54, my lord.
I don't know, because see, this is of 23/5/95. Then in June, another memorandum is issued. In the next page. And then again an inquiry. And then the final order at page 70.
My lord, 20th June 1995.
Yes.
Is my lord, this is at page 61.
Yes.
My lord, this is, my lord, they primarily found that the report of the inquiry officer is in order, and my lord, a proposed punishment of dismissal was decided.
Where is that? Which page?
My lord, page 61, my lord, just one page prior to the inquiry report.
P10.
My lord, P10, yes. My lord, this is 20th June 1995. Now, my lord, the Director of Health Services, my lord, by this memorandum, my lord, kindly consider the third paragraph. I'm sorry, third paragraph. And whereas the said inquiring authority has submitted his report, it's the comments that the charges leveled against the accused Sri Sengupta have been established beyond all doubt, copy enclosed. And as such, I, the Director of Health Services, West Bengal, being the appointing and the disciplinary authority in respect of post held by Sri Deshranjan Sengupta, Upper Division Clerk, after going through the report of the inquiring authority and other related papers, hold that Sri Sengupta guilty of the charges leveled against him and propose the
So this is the proposed punishment.
may be terminated by way of dismissal.
So before accepting the inquiry report and awarding the
inquiry report was served, and my lord, this is the, my lord, representation in connection with that.
This is the second show cause.
Second show cause.
And what has he, how he has responded to that?
My lord, in this representation, my lord, my lord, mainly there are three grounds, my lord. In the first ground, he says he was not allowed to cross-examine some of the witnesses. The second thing is, my lord, he said that he was not overall in charge of the account section. But, my lord, from the
which person has been examined in support of the charge?
My lord, these documents, your lordship will find in the tribunal, my lord, the state filed an affidavit in opposition, a reply, my lord. In tribunal, it is said reply, and my learned senior friend's client, my lord, filed a rejoinder. Now, these documents are not in this writ petition. The entire.
How do you know they filed a reply?
Yes, my lord, your lordship will find. Kindly consider page 27, my lord. Page 27, paragraph, I'm sorry.
Paragraph 40.
My lord, kindly consider paragraph 40, man. Your petitioner states that the affidavit in opposition made by the respondent number 2 before the learned tribunal is quite contradictory. Yes. Therefore, this affidavit was filed, and my lord, perhaps in that affidavit, because in original application, all the minutes and, my lord, the depositions have not been annexed.
No, therefore, we said, look at the inquiry report.
Yes, my lord.
Yes.
What does it record? Who was examined? Which document was examined? Who presented the evidence?
My lord, so far, my lord, the first charge is concerned, my lord, your lordship will find. My lord, kindly consider page 54, my lord, third paragraph from the end.
Yes.
In his deposition, Sri Sengupta denied all charges and pleaded innocent. He claimed that he never prepared the bill of class 4 staff through which more than 6 lakhs of rupees of government money were misappropriated during the period of February 86 to 1991. In his deposition, Sri Sengupta subsequently admitted that he was directed through order number such and such of the superintendent to look after the bills prepared by Sri Vishwanath Rai and sign them before placing to the superintendent. Kindly consider this. He stated that the direction has not yet been followed by Sri Vishwanath Rai, and even the superintendent himself violated his own order. That Sri Sengupta's deposition to deny charges was false and will be evident from the following descriptions. The manner in which government money was misappropriated for years after year has been described in brief in my report by Sri Vishwanath Rai. The copies of the bill in acquittance roll indicates all bills bear Sri Sengupta's put up signature before the same obtained signature of the superintendent and DDO. All corrections overwriting to bear his signature. If Sri Sengupta had not, then in my page it is not there. Check the bills.
Yes.
Becomes a violation of the superintendent's order. As deposed by other two accused, the original copies of the bill were prepared Sri Sengupta himself. Sri Sengupta claims that he had no scope to check the bills since the bills were placed before him during tiffin hours and the same was placed at the last date of every month and this plea is absolutely ridiculous. He was senior to Sri Rai. All bills went to the DDO through him. All bills bear his signature at different places as a work of his checking. All bills were prepared in this way, not for few months, but for years. I do not find any way left open other than to conclude that inflation of bills was always pre-planned and intentional, and Sri Sengupta played the most important and leading role in the nasty unlawful game. He had courteous access to the DDO without whose signature the bills could not be drawn through treasury. The Sengupta were required to put his signature at different places of the bill, not merely for ornamentation. The signature had their applications. Sri Sengupta must be knowing what weight such signature carried. If such signature made the DDO believe that the bills were all properly prepared and lead to defalcation huge sum of government money, Sri Sengupta must accept the punishment such criminal activity should invite. I clarify the position. I like to cite one instance. Page 11 of bill number 147 in acquittance roll is referred to. Total of the basic column 4 was 36,600. which was subsequently corrected and rewritten as rupees 41,600. This correction bear the signature of Sri Sengupta himself. Out of total defalcation through overdrawal of rupees 15,000 besides inflation of 10,000 in DA account. This inflation alone under basic pay touch 5,000. Can Sri Sengupta deny his responsibility? I think not. And in conclusion, I opine that such activities of Sri Sengupta shows extreme negligence in discharging duties. In fact, Sri Sengupta played the leading role in the whole affairs of inflating figures in the pay bill willfully with an intention to misappropriate government money amounting to rupees 6 lakhs as alleged in article of charge 1. So three charges were proved. Therefore, my lord, he was the custodian, he, my lord, put his signature and the bills were inflated.
We are not on that. We are on what procedure has been followed by the inquiry officer.
My lord, the procedural aspect, my lord, in the grounds of the writ petition, I found there is one procedural infirmity which my learned senior friend has alleged, that he was not allowed to cross-examine some of the
Cross-examine who?
That is not there, my lord. In the
So therefore, in your inquiry report, who have you examined that he will cross-examine?
but that point is also not there in the inquiry report.
Inquiry report does not manifest that any person was examined.
My lord, that is there, my lord.
Who has been examined?
My lord, if your lordship kindly
Sengupta is this petitioner. They are talking.
Yes,
he's-
Sengupta is the petitioner.
Yes,
My lord, there are
from the inquiry report, can you show which witness has been
although,
examined?
my lord, this is completely based on documentary evidences.
Now, so therefore there is no witness. It is based on documents. He is saying that he was in charge. That cannot be denied for
Well,
checking and correcting the bills. Now he has checked and corrected. He has put his initial signature. Then only it has been put up to the superintendent. Therefore, he cannot shirk his responsibility. Who has placed the documents? Which documents he has considered? Who has deposed in support of the documents? Has his verification, has his signature been verified? Nothing.
My lord,
So there
problem
was
is,
a
my lord-
presenting officer, one accounts officer of the Central Medical Store
Yes.
was appointed as the presenting officer, but he has not uttered a word in the proceeding.
my lord,
Inquiry report does not take note of one, even his name. Yeah, at one place it says that a presenting officer was appointed.
yes.
The inquiry report says that, but what the presenting officer has done is from the inquiry report, it is
From
difficult
the
to find.
inquiry report, since the minutes of the inquiry is not annexed, it's very difficult, my lord, who are the witnesses who were examined or cross-examined.
But that is required to be
But
considered.
yes, in the report, my lord,
The
there should
report
be
it
some
was-
reflection. Yes,
There must be a reflection.
absolutely,
So
absolutely.
there is nothing there. And then he comes to a finding. Just see the nature of his finding. What is his finding, ultimate finding?
The ultimate finding, my lord,
I do not think that I need to go into any further detail to prove that charge is established. Above this is extreme negligence in discharging duties. He has rightly been charged with misappropriation for the reason stated. And what does he say? Is liable to face disciplinary action now under the relevant rules. What does that mean?
no, my lord, it
He doesn't
appears-
say proved, he doesn't say disproved, he says he is liable to face disciplinary action now under the relevant rules. So what action? You are the person taking the action. Where is the finding of the inquiry officer? That's why we asked you, what is the finding?
no, my lord, the
The activity does not only prove. Now see what he says.
page 3, my
Page 4, yes, we can read from page 3, yes.
my lord, the second chart, my lord, page 3, the second paragraph. My lord, may I just read, my lord? Reference has been made of bill number 423 dated 17 January 89 in the same article of charge 2. Through this bill, pay of 110 GDs has been drawn gross and total amount being 1,25,220 and rupees 1,96,286 respectively. The basic pay of 15 employees from serial number 81 Ganesh Chandra Mollik to serial number 95 Pulin Bihari Shao has been increased by rupees 1,000. Sri Mollik's basic pay is shown to be rupees 1,260, whereas the same should be rupees 260. Similarly, the basic pay of Sri Shao has been endorsed as rupees 1,266 in place of rupees 266. The net amount payable has also been shown inflated by rupees 1,000 than required. The manner in which rupees 15,000 has been
You want to
defalcated.
place any material on record from the
My lord, I think, my lord, the inquiry officer, my lord, proceeded on the basis of all documentary evidences.
sir, that is the whole problem. Who presented this material?
Must be the presenting officer.
It doesn't manifest from the inquiry report. Whether he is stepping into the shoes of the presenting officer, taking out one document after the other, and passing it.
Should be exhibited.
So therefore, he has a prima facie good case, according to us, subject to what you may say.
My lord, may I produce the entire record, my lord?
No, you just whatever was filed before the tribunal, you complete.
My lord, very well. My lord, the presenting officer, in so many words, has not referred to any exhibits, my lord. He, on the basis of documents.
See what he has done. Fourth paragraph at the first page of the inquiry report. Just read for yourself.
Paragraph, yes.
Just read for yourself.
এই তো রিপোর্টটা
This is expected from an inquiry officer performing quasi-judicial function. We'll see. We'll see. You may produce if there was a WS, whatever you have filed before the tribunal. If there is anything missing from the tribunal records, you can place it on record.
My lord, affidavit in opposition, my lord, filed before the tribunal. I will request my learned senior friend because I do not have it. It's not. I don't. Because my lord, department sometimes do not retain these copies. It is.
Yes, it has remained dismissed in default for such a long
My lord,
time.
I will not take much time. Kindly give me 2 days time. I shall take instruction. The file should be there. I shall produce the file and I shall see, my lord, how.
So see, we propose, he is no longer alive.
Yes, yes.
We propose to dispose of the matter on merits this way or that way, whatever. So we'll allow the restoration. You may
Yes, yes,
file whatever you want to
yes.
file. And then we'll see,
No, I
because
don't want to file
contempt
any-
also, I don't think there is any force now. Because it was dismissed and all orders went.
Yes.
Now only when it is restored, the order may be looked into or may not be looked into. So since we are finally dealing with the matter, at the moment, we are not inclined to proceed with the contempt issue.
My lord, yes. My lord, if he is entitled to receive, apart from, my lord, if the dismissal order sets aside, then my lord,
The whole thing will
wife
change.
Get everything.
Everything
Yes,
will
yes.
change.
And so far,
If not, then this interim order is,
yes, yes. Now, the question.
even then we may leave an opportunity if there is something remaining unpaid, it can be considered.
My lord, the only question of law is, my lord, the propriety of the inquiry report and the final order. Now,
Yes, see,
now
the issue is we are
No, report to.
we are exercising judicial review.
yes.
We are only concerned with the procedure. What is the procedure adopted by the inquiry officer? We find from a reading of the inquiry report, subject to what you may show from the records, whatever you have filed. We don't know in your reply before the tribunal, because it must have been filed here. This writ petition was instituted here
Yes.
and then sent to the tribunal.
Yes, yes.
The earlier it was a writ
Earlier, my
petition
lord, because the tribunal was set up
prior to
and it
95, yes.
was a transfer
So
application.
after the Administrative Tribunals Act came into force, it was sent to the tribunal. Therefore, we don't know whether that reply was filed here or it was filed there. This has been transferred in 97.
Yes, ma'am. 97. TA 97.
And writ petition is of which year?
My lord, this
Is there any
petition
way
is
to
of
ascertain?
My lord, he was dismissed sometime in 1995.
So
Maybe
must
immediately
probably just
thereafter.
before coming into force of the act, he would have filed the writ.
Immediately thereafter, my lord, maybe in 96.
Yes, take down.
one thing. There is another application for condonation of delay that your lordship cannot
Dispose of, what is the number?
can 4 of 2023.
Can 4
Yes,
is
my
for
lord.
substitute. Oh, it's a
No.
common
Can 3, my lord, is application for restoration,
restoration.
and can 2 is for application for substitution. Then can 2 is substitution. Yes. 3 is restoration.
Yes.
And 4 is, my lord, condonation.
Condonation of substitution.
Condonation.
For which original?
Oh,
For condonation of yes.
substitution is
Yes.
can 1033.
Fine.
1033 of 2011.
Yes.
Subsequently numbered as
My lord, can 2.
can 2 bracket में लिख देना. Hold.
No.
Give this back to me.
Grateful to the Lord. হবে ওটা? হবে?
Spend time on.
হ্যাঁ?
23 তারিখ।
Number 9.
9, I appear on behalf of the petitioner, my lord. So this is a review application. Against the order dated 11th September 2019.
Which order?
11th November 2019.
Yes. What is the ground for review?
But only one thing, but if it is apparent from the record that some wrong is committed, then review is applicable. Apparent on the face of record. Now, this is the second round litigation. But kindly allow me to make 2-3 sentences. In previous round litigations, they sought for appointment before the tribunal. Tribunal refused. They went to they come before the Honorable Court. Division bench pass an order directing the authorities to allow the applicants therein, to including this petitioner herein, to participate in the interview process. Against that, they went to the Honorable Supreme Court. Honorable Supreme Court also held that yes, you go there, participate in the interview process, and then if you are selected, then appointment is to be given. That part has been completed. Now the petitioners, this is the separate entirely proceeding is there. The petitioner participated since long.
They are not allowing you to argue the matter afresh.
No, not
What
that.
is the error apparent?
Error-
Which page is the apparent
Yes.
error? What
At
is this?
at
Everybody
page-
will file a review and re-argue the matter.
No, not at all. Not at all.
You are arguing for this long, that means that there is no ground.
Certainly not.
That means there is no ground.
No. Certainly not.
Show from the record.
Yes, Lord.
What is
Page
this?
2.
This is abuse of the review jurisdiction.
No, no, no.
We will impose some costs.
No, no, no.
You argue whatever you want to
No, no,
argue.
no, I will not.
Yes, you please.
The
What is
application,
this?
petitioners made application before the
As it is, the writ court has held that you are trying to resurrect a lost cause up to the Supreme Court, and now you are filing a review.
petition.
As if you are to re-argue the entire matter,
Not at all,
2020 matter.
Not at all. Petitioners pays for the under Right to Information Act.
We are not going to listen to all this. We are not going to listen to all this. This is beyond the scope of review. What is the review? What is the scope of review? You tell us.
But only this for the previous round.
What is the law?
If it is found that on the if it is on the face of record.
What is a error face on the face of the record?
The second round.
What is an error apparent on the face of the record?
Yes, Lord, that I am saying.
No, you are not saying. You are trying to argue the case. What is the law? What is an error apparent on the face of the record?
Error is.
Yes.
Error is not the previously on the basis of merit. That I am not. Second, here not the petition made application under Right to Information Act.
We are not going to listen to all that.
Only that, not the.
We are not going to listen to all that.
Only to provide that information. If your lordship go through my way, the second way, if lordship will kindly see it appears that only the petitioner sought for the document of the 95 selection. This is only. The prayer is also there to provide the document. But may I just, there the way,
You may not.
only the, may I just,
No, you may not.
I leave it to your lordship. I not only, I have gone through the way, but the prayer of the way is to provide the information because the right to information application was made. First appeal was made, second appeal was made. No information has been provided. That's why the way has been filed. That I have gone through. I had also not gone through the SLP, copy of the SLP, where I could not find that any points of law or grounds has been taken for supplying the documents. This is my humble submission before your lordship. Only to provide the document. But I have the copy of the way. If your lordship want to peruse, I shall hand over this.
What is the first paragraph of the order?
Yes. So that is the OA 8880 of 2016. But with the tribunal was pleased to reject the original application, principally on the ground the prayer for production of the record of the selection process 95 cannot be granted. That was what
rejected.
Yes.
That it cannot be granted. Now, what the division bench has said about it?
The division this is the division bench also says that since the petitioner went to the Honorable Supreme Court and Honorable Supreme Court directed to participate in the selection process, that is all merit. So not entitled.
There is no need to look into the records now.
The Supreme Court has the subject to lordship kind correction.
Now the division bench has said that there is no point in looking into the records.
Yes, absolutely.
So it has decided this issue.
But according to me, my humble, the submission before the lordship, their issue was.
Mr. Counsel, please respond to the court's query.
Yes.
Regarding production of documents, the tribunal said it cannot be done. The
Yes.
division bench also said that it is pointless exercise because after that you have gone to the Supreme Court. There is no question of looking into the documents.
Yes.
Now, therefore, you are saying that we should still direct for giving the records, even though rejected by the division bench.
Because earlier division bench, that issue was not considered.
It is considered. Read the order again.
This is the order of the present appeal, present writ petition. The previous previous order, it is annexed with the for this reason only not come before this court. Other nothing. Petitioner cannot raise any other question. Only to provide the information on the basis of RTI application. Only this. And now I leave it to lordship if lordship decide.
You are the appellant before the Supreme Court also.
Yes. There are 6 applications, probably 6.
There is no problem of funds for you.
No, not that one. But unemployed youth already crossed the age 60. Lord, ground number 3 may be applicable in respect of this prayer, and Lord, ground number 7 is also Lord subject to your lordship's kind consideration. The previous way was but that is here, but relating to this proceeding. Prior to this,
And when another way, 508 of 2001.
2001, that is the
5090. 90. Then way number 508 of 2001. Then third way, that is
880.
He did it WPSP. Last WPSP by Justice Datto. At the other
WPSP.
Justice Sengupta.
That I have found.
Against which they went up to Supreme Court. As a Supreme Court. Yeah. And SLP with a reason order.
Yes, yes.
Not summary rejection. Page 3 of the.
Yes, yes. That is the quoted. What has been quoted?
Of the order.
Impugn.
Impugn order. And Honorable Division Bench cautioned the petitioner making some observation against the highest court. That order passed by the Supreme Court a party interior.
Yeah.
Yeah. What is Justice Doctor?
No. This is the first time, Lord. Yes, day before yesterday, this graphic, no objection has been taken. Lord, today I am first time appearing before your lordship in this matter.
As such order presumed to be party.
Yes, yes. But earlier advocate. But today I shall file. I shall undertake. Lord. Yes. Lord. Yes, this is the book. No, stamp korene. Just the yesterday evening he has given the blood brief. Advocate in the in the review. Read petition. No, not there.
There is either he must give an objection or file a review application.
Before the read court, then probably not he has filed the. Is there any vocal number on her part or his part? No. যদি রিভিউটা ফাইল করতে তাহলে ফ্রেশ ভোকা যদি যায় তাহলে তো দাঁড়াতে পারবে।
No.
But no. Not he is a. Since the review has been filed. Just now it has been, but So kindly beg me pardon for this, my lord. I should. But I said, no, this is, but I was, but this is, but I beg pardon, my lord, for. But I beg pardon, but I should not, because today just morning he has given. No, not kindly, my lord. Kindly, my lord. Nama, my lord, filed, my lord, this should be signed by other advocate, my lord. Yes, my lord. Turun Kumar Das. Not one of the junior, my lord, he is in code number 18 now. But he will sign the Nama, not by myself. I shall, my lord, if your lord, I shall argue, my lord, I shall place the case. But I since but certainly, my lord, I'm taking the blood. I'm taking the yes. Not I am not. But since he will sign, that's why he was. But I shall sign in this matter. Whatever mistake were committed by me. No.
Number 10.
Monday.
Item 10, my lord, I appear for the petitioner.
Just what intention will be released as soon as statutory clearance.
But only difference, my lord, only I will see, my lord.
Yes, please tell us.
But page 41, my lord, there is a rejection order. My lord, lordship may set aside the rejection order. So that will be a hindrance, my lord.
We'll say that
as well.
We'll deal with that. Page 41.
Page 41 is the rejection order, my lord, one line rejection of duct of doctors.
That was impugned before the tribunal.
Yes, my lord, that is also impugned before the tribunal. No, ওটা impugned before the tribunal.
That was the prayer in the OA.
Yes, my lord, page 27, your lordship, kindly have a look. Page 27, prayer A, an order to issue thereby setting aside quashing the impugned rejection order passed by the respondent authorities regarding the prayer of applicant for resignation from government service with effect from 28/2/2025, communicated by the Deputy Director of Health Service Admin, wide number such and such dated 18/6/25. Well, this 41 is 18/6/25 letter.
Original office can be disposed of.
না না এটাকে রিজেকশনটা সেটিসাইড করতে হবে হ্যাঁ না ওটাও
18/6/25. Yes, that is the order.
দ্যাট ইজ আন্ডার চ্যালেঞ্জ
An order dated 18/6/25 You are saying under active consideration. There is a new incumbent on the post. So now he will change everything. Or he is obliged to maintain a uniformity.
No, whatever. Most probably they are assisted by the joint secretary law.
So they will just sign whatever is put before them.
The court matters, they will.
They must apply their mind.
Certainly, madam.
No, we are not going to accept this. This is at variance with the letters issued in respect of other persons. What is the basis for discriminating against this person?
No, nothing.
Then why you should use a different?
Clear surprise, you will be released.
No. What is active consideration? Where is the acceptance? You have specifically said, we have been recording in all the orders, that the government has accepted and only vigilance clearance is now pending. Here you say is under active consideration.
No.
Where is the word accepted?
Vigilance clearance, and state vigilance they have to obtain. And other obligatory procedures to be finalized. That will some.
Huh?
In this case, vigilance and clearance has already.
Then what remains?
And other obligation.
What is the other obligation?
No liability certificate.
Where have you said?
And other statutory obligation procedure.
What is the other obligatory procedure?
First one, as far I can remember, no liability certificate or no due.
So a vigilance clearance, is it given prior to the acceptance or after the acceptance?
First, vigilance clearance when application is filed, then when the government decides that he will be released, then will be sent to the vigilance. If vigilance case is pending, then it will not be processed. Now, if vigilance clearance is obtained, then other formalities, that means no due certificate.
That means that if the government has decided to accept, then only vigilance clearance will be taken. Is this the situation?
My lord, only thing my lord is same, my lord. In this case, my lord, the petitioner before lordship is my lord, member of West Bengal Health Service. The others were West Bengal Medical Education Service. My lord, the health service, my lord, we seen, my lord, I may not be saying, my lord. In every other time, my lord, we are facing it, my lord, block with regards to health service. Any matter, my lord, be that a resignation, be that pension, be that transfer, be that posting, even, my lord, if I have to join, my lord, I'm being restricted. With regard to health service, things are not, my lord, I may say, whatever experience I do have, my lord, it's not proper, my lord.
No, we are, see, in an appropriate case, if something like that comes, we will deal with it. That's not an issue. What we are saying is, what he's telling us, that only after the government decides that he is to be released or his resignation is accepted, then only vigilance clearance is obtained. If that is a fact, then because vigilance clearance has been given means that there is a decision to accept.
Other formalities, whatever, no due certificate. If there is a loan or house loan or something like that.
Take down, we'll take down the order.
Matter number 11.
The last occasion, yesterday, your lordship wanted to know what is the state of Arjun Kumar Surel. But I have got instruction, government has, Commissioner of Police forward entire papers to the government under the rules forward, before appointment has to be placed before the roster and MIC approval is necessary. Because Commissioner of Police has no power.
So they are implementing the order. They are not selling the order.
No.
Oh, these order passed by your lordship on 26th August 2025. They are complying.
So therefore, we have to see whether it is covered by the judgment or not.
Absolutely.
Now let us see.
Yes. Well, if your lordship kindly turns to the judgment of Arjun Kumar Soren. Only one line, if your lordship. Paragraph 12, I have handed up the judgment to your lordship. Paragraph 12 of the judgment, it says that the compassionate appointment cannot be transferred to anyone. It is therefore immaterial whether the transfer is the son, any other family member, or any person outside the family. Copy hai Arjun Kumar Soren. After offer of appointment or any appointment on compassionate ground has been made non-transferable, and status or relationship of the intended transfer is not relevant. In the present case, however, we find that there is no issue of transfer of an offer of compassionate appointment. Thereafter, my lord has dictated the order. Now, my case is, my mother who applied for compassionate appointment, son. Yes, but it was in
2nd October 1992.
Yes.
2nd October 1992.
2nd October 1992. Yes. Yes, within time.
Mother applied on 15th February 1993.
15th February 1993. Thereafter, a series of communications were there between the respondents to grant her compassionate appointment. I am not going into that. Thereafter,
In your favor.
yes, page 49.
Page
49, 49. 22nd of June 2006. He made the application to the Superintendent of Police.
What page did you say? 49.
49.
Very well. Then 3-member committee.
Yes. The affidavit in opposition filed by the state, page 36, 37.
Page
36, 37 of the affidavit in opposition filed by the state. 37, last paragraph. Last two paragraph, moreover, as per.
25/9/14.
Yes. Last but one paragraph, moreover, as per the report of the Inspector in charge, Balurgarh Police Station, it is clear that the family has no other source of income excepting the family pension. Hence, the financial condition of the family of the deceased employee is...
This is followed by the rejection.
Yes.
Where is the rejection? 5719.
It is
Page 43. 43
accurate.
by the state government.
Page 43. 13 September 2024.
Yes. And what is the document preceding this, just before this, in the opposition?
It is the at page 41. The Superintendent of Police is writing this letter to the Director General of Police in 2019. Page 42, serial number 6. The petitioner's case has been sent for
So
completion.
he is reiterating.
Yes.
This is page 41.
41, 42. In the affidavit in opposition.
All right, we'll come back.
2 p.m. matter item number 136.
136. Just read the last, will not read the entire thing. We find that there is no issue of any delay and latches coming in the way of grant of benefit to the petitioner. In terms of the order passed in the case of Pritam Ghoshal, the present petitioner may have been deprived of parity only if his claim was suffering with the vice of delay and latches acquiescence, or if it was found that the petitioner was a fence sitter. There is no factual foundation for such inference to be drawn in the present case, since the present petitioner approached the tribunal for the self-same relief by filing away prior to Pritam Ghoshal. The plea taken by the state in the opposition that petitioner is a fence sitter is unsustainable in fact and in law. In view of the above consideration, there is no basis whatsoever to deny the petitioner parity with Pritam Ghoshal and extend the same relief as was extended to him by the tribunal by its order dated 14/12/2020, passed in OA number 940 of 2019, affirmed by judgment dated 9 8 weeks from the date of presentation of a copy of this order downloaded from the internet website. After his name is recommended, the respondent number 1 shall appoint him within 8 weeks. The application is allowed.
Yes.
All pages I will initially touch.
Continuing matter item number 11.
But your lordship's last query was page 41 and 42. The of the affidavit in opposition filed by the state, where the Superintendent of Police Uttar Dinajpur had forwarded my name. Yes, reiteration. Yes. Yes. that 251 EMP.
10A. Double A. Yes. Criteria for immediate financial need of the family in terms of the rebatable related. Because of 1992 and 2024.
No.
No.
Page
Yeah,
page
we have
101. Here they have filed.
Here we have filed a petition.
Page 101 of the petition.
No, only but a condition. So far as the order passed by the government that rejection order at
43 of the affidavit in opposition. From your petition. '56. '26 EMP. 26 EMP निकालो तो.
yeah. Whatever. First one, they took place in 1992 and the application filed in 2006. This gentleman. Now 92 to 2006. If they could have waited, that for the financial need to be tested or not. Immediately. Number two, at the according and if somebody was eligible according to the scheme at the time of death, that lady applied, lady was considered, but she was not eligible for constable. That's a group D post was allotted. She was in the queue. No vacancy was available. But immediately that son could have applied, but she. Yes, yes. Yeah. On page 4, opposition. Paragraph 6. Kindly see page 3. Date of death mentioned, then thereafter, this office sent a letter with a prayer of the applicant Srimati Jharna Mondal on 16th February 94 by memo dated Dato before the Deputy IGP for employment group D post Srimati Jharna Mondal of Astro Yojana, Kasba, as there was no post of group D Uttar Dinajpur district. And I have got all the documents. Admitted position, the Jharna Mondal was recommended for appointment in a group D post. But because no group D post was available, it could not be considered. Then in 2006, she applied that instead of my application, my son application should be considered. His application could not be considered until there is a physical fitness. Then when the local SP fitness certificate was considered, then principal prosecutor that fit, then recommended forward to the government under the scheme. Then government recommended on only two grounds, practically two grounds. That means at the time of death, he was not measured and eligible persons was there. But unfortunate reason that no group D post was available. And second is from 92 to 2006, they could continue with this long gap. Only this. And the term completion appointment is a very sympathetic consideration. You know what? Don't take it, don't record by consideration, but sympathetic consideration by the government.
Guided by sympathy.
Sympathy.
And and sympathetic approach takes 14 years.
And
even in 14 years, nothing happened.
They could survive for last.
That is, they should not have, according to you.
And government is bound by the.
Is it their fault that they have survived?
No, no, no.
What is the percentage of posts allocated to?
10%.
Oh, 10.
Only 10%, and there will be no.
We are saying 10. You are saying only 10. I come up from a state, there is only 5%.
No, 10%. Then vertical reservation, horizontal reservation.
That is there everywhere. No, in compassionate appointment also there is a.
Yes. If there is scheduled caste, scheduled tribe for OBC. Yeah.
No, but the person who dies in harness, he vacates the same category of post.
Same category post of category.
Oh, but he may not be appointed on that post.
Because appointed in 1987, 86, 87. And it is very difficult to meet such a situation. And the lady suffered a long non-ability of the post. Yes.
One document I want to show. Page 43 is the type copy. Now, what Mr. Mukherjee is saying that there was no post. The additional SP is writing a letter, page 43 of the writ petition, to the Deputy Inspector General of Police, Redesville in Kolkata. There is no post of Group D which is lying vacant in Uttar Dinajpur, for which Jharna Mondal, my mother, can apply. Then, he is requested to kindly arrange for employment of Srimati Mondal as Group D employee in so-and-so 4th Battalion, Koshba, which is in Kolkata. An early reply is requested. So there was vacancy. And thereafter, my mother, once again, page 44, wrote a letter. In the district of Uttar Dinajpur, where I come from, there was no vacancy, but in Kolkata, there was vacancy. But regarding that vacancy, which Mr. Mukherjee is pointing out before your lordship, but this is their document. The
The other persons on the same district.
Kota. Kota. No, but this is the document which I am having.
Vacancy.
That was in 94. In 2006, for the first.
No, but that is not my case. That is not my case. Not the case of it.
My case is may I point out page 48? As and when vacancy occurs, but in 2006 also, 2001 also. Yes. Now, thereafter, in 2006, when she got a call, she wrote a letter to the respondent. Yes, sir. True.
Group report.
Absolutely, but only one gap from 2001 to 2006 till my mother wrote this letter at page 49. But switching over the employment from herself to mine, there is no explanation coming from the side of the government. What was the vacancy ratio? This is number one. Number two, in the
No, unless you make, that's again we are saying, they will not do it. Unless you make a specific assertion that there is a vacancy, despite existence of vacancy, I am not being considered. Why should they?
Now, thereafter, what I'm on is, after the case.
It is not your case either before the tribunal or before this court that despite subsistence of vacancies, my mother was not considered. If you can show this from any document, any averment in any petition, then we'll ask them to bring the entire records.
Well, my case is absolutely on a different periphery.
Exactly. So now don't try to make out that case that vacancies are existing and they have not shown the records. That doesn't matter at all.
I've never said.
Yes.
But my case is that the moment my case was sent for consideration and my case was considered by three-man committee and also I was physically.
Everything else we have seen. So the issue of vacancy was only.
Page 58, re-examination of compassionate appointment. It is the Deputy General of the Director General of Police writing it to the Assistant Secretary, page 58. Can you have a look? He is saying that in view of the above, government is requested to consider the matter of employment under exempted under the page 58. Can you have a look?
So if that is all, Mr. Mukherjee, then
the candidate is recommended.
Heard the learned advocate for the applicant writ Monday. Will come under the heading for orders. Monday or Tuesday? Tuesday.
Number 12.
My lord, I am appearing on behalf of the petitioner. My lord. Here the lordship please to direct us to take instruction regarding compensation we have already paid, my lord. May I place my report, my lord.
Give him, please.
Lordship. My lord, here the petitioner's case of compassionate appointment has been rejected on the ground that he has not made the application in a pro forma, in the format of pro forma, my lord. Without considering, my lord, 3 members committee's report and as well as, my lord, the earlier communication of the authority that they have communicated to the petitioner due to the lack of vacancy, they cannot be presently accommodated. And your lordship kindly see your lordship's last order, 19 January 2026 order, where your lordship was pleased to ask to produce 2015 circular, my lord, where any person can make the application in the plain paper also, my lord. Kindly see. কি কথা বলছি?
Bring it this side. Keep it here. Yes, you are not answering our query.
We have said, but they have lordship kindly come last page, my lord.
What is it? Nothing.
Last annexure, my lord.
What is the, where is the rule or guideline? How this amount is calculated? You pick out from the hat whatever amount is, whatever amount you think, or there is some method.
But not clarified. I have said that my lordship may I place, my lord. The governor has been pleased to sanction allotment of some of the.
Why? Why not 1,50,000? Why 2 lakh rupees?
I have said so.
Why not 1,50,000? You have not answered the court's query. We reject this report. The report filed today does
Number 13.
Please, Your Lordship, this is my application, Lord. For last occasion, Your Lordship are pleased to direct the AGP, my lord, to produce the statute in which, my lord, the petitioners have been
The petitioners,
have been engaged, my lord, or appointed.
acha, that
Civil
civil defense volunteer.
Your Lordship. For the last 16 years, my lord, they have been working.
You are one of them.
I'm one of them.
We want to see what is the government's scheme, how they are doing this. Where is he?
He was here, my lord, perhaps.
Did he give you a copy of anything?
No, nothing.
It was already there.
Must be in some other court.
My lord, then, my lord, Your Lordship, kindly.
Mukherjee is appearing.
That we know. Where is he?
Not
All right, not today.
Up to 17, my lord.
Up to 70.
Up to 17, I'm paying for nothing. Your Lordship.
Not today means it will come on.
Item 18.
Even 18, I am for the petition. Reply.
Filing a reply.
I am filing the reply.
41. पैसे की सर्विस हाँ पैसे की सर्विस को
When the pro forma application was submitted,
Actually, the pro forma application was made in 2021.
give the date. We want to see the date.
Actually, it's 19th of January 2021. It's a page number 29.
Yes.
Sure, but the fact remains is that in the year 2017, in the month of February itself, there was an application made in plain paper. In 2019, by acting on basis of that application itself, the respondents directed the petitioner to provide certain documents. There is a form in this regard which was provided to us, and accordingly we prepared the documents and filed the pro forma. And in the meantime, my lord, in 2016 itself, there is a notification that if there is any technical latches in an application, that has to be made known to the petitioner. In this case, my lord, nothing has been done.
Where is that provision?
I should kindly takes up page number 41 of the reply. It begins from page number 39. It is a Labor Department notification dated 1st of March 2016.
Where is the provision that says that any technical deficiency must be intimated?
You kindly take the page number 41. Page number 41, Lordship, the first point.
Yes.
Revised provision in the Lord right hand margin.
It does not say what you have just said. We have seen this many times. It does not say what you have said.
Lordship, it says that the concerned authority in the department should meet the members of the family after his death to advise and assist him in getting appointment on compassionate ground. The applicant should be called in person at the very first stage and should be advised in person about the requirement and formalities to be completed by him. A record of such meeting should be kept with the office of the controlling authority.
So it does not
All
say
cases
what
of
you have
appointment.
submitted. It does not say what you have submitted. That's why we are saying.
Not particularly, Lordship.
Not particularly means what? It is not there. Then it is not there. But particular or unparticular hardly matters.
Even if that be so, there is a duty.
It is so. Unless we gave you an opportunity to show, you have not shown. Therefore, it is so.
Lordship, this provision, Lordship, shows that when upon receipt of that application, it is a duty on them.
Nothing is a duty upon receipt. It is a duty without receipt of application. This notification exercises the benevolent intention of the scheme, saying that the persons who are suffering such an immediate crisis, they must be advised. You go and tell them that, look, this is how you have to make an application. Not only tell them, maintain a record of what you have done, how you have interacted. It is not that once an application is made, they are advised to come, obliged to come and tell you, give you a communication for rejection. They have given you a communication for rejection.
Actually, that was what I am
Plus,
saying. That
the making in this notification itself, you have perhaps, we don't know. Yes, you are appearing.
Yes, my lord, I do not know what is the question, my lord, that has been.
No, he said that under this notification, there is an obligation anyway, that is over, forget.
You have to advise the petitioner not to make an application.
Yes.
Yes.
Is in person about the requirement and formalities to be completed by him. Whether, my lord, it can be elongated to such extent, subject to what my lord will say, my lord, that, my lord, that this is, my lord, so that this is the intention of the government, my lord, possibly it's a policy, my lord, that it is a general, it is an exception to the general form of appointment, my lord. So that is possibly, my lord, if I have correctly understood the minds, my lord, that, my lord, the applicant should be called in person at very first stage and should be advised in person about the requirement, so that the communication should be completed, my lord, so as to enable the person concerned, my lord, to my lord, respond in a particular manner. Otherwise, my lord, this sentence.
You have missed, there is a notification exempting the making of a pro forma application. That's no longer a requirement after 16.
Yes, my lord. That is then, my lord. I do not know, my lord, whether this has been superseded or in modification of this, my lord. If
We
it
have
runs
seen in
parallelly, my lord, if I get the time, my lord.
that whether after this, my lord, has been
See, plain paper is omitted. Plain paper application submitted within can be accepted, deleted.
2016.
Then 2016.
And this was incorporated. This was incorporated.
And this was incorporated.
That says that if a plain paper application is submitted, it has to be followed up by a pro forma within 6 months. That is deleted. So now there is no requirement of following up with a pro forma application.
It says, Millard, the notification.
7-8.
Yes.
Please read and tell us, enlighten us what it
No,
means.
Millard.
No, we
Millard, the
want to
ramification, Millard, if it is deleted. And
please read what is deleted.
Yes, deleted plain paper application submitted within 6 months can be accepted as a valid application, provided pro forma application has been submitted subsequently, but not later than 1 year from the date of death, incapacitation of the government employee. The administrative department must be doubly sure that the plain paper application was really submitted within the
So all this is deleted.
No requirement. If that is so, Millard,
our little understanding is like this one.
Millard, I am before, Millard, the highest court of the state, and whatever your lordship will say, Millard, that is the final.
In the first half, in one case, one learned advocate had given us the notification showing the exemption. Pursuant to which,
Millard, the state was represented. Then
yes,
I can, Millard.
Mr. Mukherjee was appearing.
Then, Millard, I will contact him, Millard. I will.
We have the entire compilation here, because this is something which is occurring in so many cases. We had gone through this provision, therefore it is stuck in our mind.
Right.
But if it is that notification is placed, then this will be clarified, because that takes notice, that the department takes notice of the fact that this has been, the authorities are facing difficulty repeatedly because of this. Otherwise, this deletion read with that provision which he read, which he placed.
Millard, may I have the opportunity to talk with Mr. Mukherjee? Millard, he was there. Millard, he was না জজ সাহেব যখন বলছেন দেখেছেন তখন
Actually, my memory is not that good. I can't remember his name. He was appearing, he handed us copy of the notification.
Today when the matter was taken up.
Today it was taken up, but it was adjourned for some other purpose.
Cannot recollect the name.
Okay. His lordship also cannot recollect.
My lord knows.
I know, but I cannot recollect the name at this moment. The name of that group.
Item number is also, my lord. Compassion department, এটা ছাড়া কোনো মামলা হয়েছিল আজকে?
That notification in the first half they had given, which we have returned. No. I think it was Mr. Mukherjee was appearing that.
Mr. Shen was not there, no? Mr. Amol Shen was not there.
surplus compassionate.
Milord, no problem. Milord, I tell your lordship, because if the orders, Milord, that have been passed today, Milord, till the matter, Milord, we will search the website and find it out, Milord.
No, but we didn't take it today because it was adjourned for some other purpose. Otherwise, we would have told you right now. Just give us a minute. 23/9/15. This is referring to 23/9/15. This is the amendment.
Yeah, 2016. ফার্স্ট টপিক যে ডিটেশন নিয়েছিল এখন সেটা হচ্ছে প্রধান শেষ তো নেইনি কোনো এটা আমরা একটু মনে করতে পারছি না এখন ঠিক আছে হবে 1 থেকে 7 বলছে হ্যাঁ এই জজ সাহেবের এটা কি ইয়ারে যায় ইউটিউবে হয় হ্যাঁ তাহলে অর্ডার দরকার নেই ইউটিউব থেকে তো দেখে নিতে পারবো ইউটিউব থেকে দেখে নিতে পারবো
You think that it must have been this only, this 23/9/15?
Milord, don't worry, Milord. We will search out from the YouTube, Milord, today's proceeding, and we will find it out.
No, it is now.
Yeah.
Now I am sure it was this notification. The notification of 23/9/15. Request that you were just reading, which has been
Yes, notification 2017. Yes,
This is this
278.
This is what was being handed over.
Yes, but this is, Milord. This aspect, Milord. This requirement has been deleted. An introduction of the new one under the column of caption of revised provision.
Yes.
A simplified application pro forma will be introduced soon. Will be sent to the all departments. A simplified application pro forma, whether this has been carried out this order. Thereafter, Milord, a simplified application form pro forma will be introduced soon and will sent to the departments in due course. A checklist will be prepared by the Labor Department, whether this has been complied with after 2016, Milord.
Still following the earlier
Huh?
This has not been deleted.
And Milord,
in this case, we would like to decide whether there can be an insistence on a pro forma application being made within time.
Yes.
If the application has been made within time, then insistence on a pro forma or non-filing of a pro forma, whether it will disqualify.
Yes,
That will consider.
the state is unrepresented. Today, state is represented. State is not represented.
Why you for?
He is pro forma.
For the added respondent numbers 1, 4, and 5, Your Lordship, not for the state.
Competing claims.
No.
Respondent numbers 4 and 5, added respondent numbers 4 and 5 are the daughters of the petitioner herein, and the added respondent number 1 is the mother.
You are also claiming.
No, since your lordships are confronted with, Milord, rival claims inside the family, Milord, that is why in order to eradicate the doubts from the minds of your
You are
lordship.
supporting your claim.
Yes, in a way.
We are supporting that. That's my
But-
instruction.
The state then.
এটা কে বলনা
MS Asmita Chakravarti.
হ্যাঁ কি নাম
MS Asmita Chakravarti.
না তুই তো জানিস না Oh, yes, I know her, Milord. I will inform her. I will inform her.
When should we take it up?
Monday, Milord. Deeply obliged.
There is none to represent.
What is your problem? Online করতে পারো না তাহলে
The issue will have to be considered keeping in view the recent decision of the apex court. in Devabrata Tiwari, which says, arising from this court only, that strictly in accordance with the scheme and policy.
Milord, another aspect with deepest respect and humility, Milord, when the court had decided, Milord, the dearness allowance matter, I had appeared, Milord, before this honorable court, Milord. The court had taken care of and note of, Milord, the consumer price index, the present inflation, everything. Milord, in this case, series of matters, Milord, your lordships have been confronted with the decision of the Supreme Court, which is a mandate under Article 141, Milord, which says, Milord, time goes, compassion goes. When the government has framed a scheme and government is quite aware, Milord, today, Milord, by a flux of time, Milord, the poverty, the unemployment generation, everything, Milord, this is a social problem, economical problem, Milord. This cannot be eradicated like this. With the efflux of time, Milord, your lordship cannot say. Possibly, subject to correction, Milord.
That is a possible view, what you are saying, but you always have to bear in mind that this benefit is how it is to be read with the constitutional provision.
No, constitutional provision, Milord, if your lordships take it, that the Milord, preamble, if it is a part of, Milord, the constitution, and obviously it is, Milord, then justice is always social, political, and economic. And if it is an economical justice, Milord, Milord, when suppose, Milord, I am before your lordships, I said, Milord, it is very difficult, your lord, since your lordship comes from the bar, Milord, your lordship had enough experience to see, Milord, the plights of the common man. The 10 years, Milord, have passed. When, Milord, on the last day, Milord, your lordship, Milord, had taken note of the tribunal matter. We had to come before your lordship. The lawyers are virtually, Milord, the jobless. And your lordship expressed your lordship's agony, then why we are silent? We have no place to go. Unless, Milord, the protection gives from that side, Milord, we are really guardianless. Because the assurance that has been given from that building, Milord, that is obliterated, Milord. Which is, Milord, this side, Milord, because that is, Milord, stomach-oriented philosophy and election-oriented philosophy, which your lordship has no obligation to stand for something, Milord, and to go to, Milord, every door and knock the every door that please elect me. That is why the separation of power.
You are appearing for the state.
18, you are there? No.
In court, so we thought perhaps. We saw her rushing. So we thought that.
Yes, Milord. She is always tense, Milord.
He has to counter people like.
Milord, once upon a time, Milord, in this corridor, Milord, there was a gentleman, Milord, a very eminent lawyer, but he always, he was in a habit of losing temperament all the time, Milord. And Milord, and that is even if he used to lose, Milord, a very good case, Milord, because of his temperament. But he's a very erudite man. He was a very learned man of letters, and Milord, his erudition was something else. His name was let Ashish Sannal, Milord. He, Milord, passed away. He used to tell me, you, whoever you may be, even if don't forget that resistance survives on the generosity. The pain says that the pain is infinite. And for all the mirrors, he never understood. But I cannot, nobody under the sun cannot be a good concept unless the base. Whatever we do, whatever we do, I have seen Milord many experience that the bar and wage reaction outside Milord is legal rights. That is why the relationship works. Because I have accepted this institution, I have accepted the Russian in absence of
Please inform the learned state.
Number 19.
Last date you disappeared. Today you are appearing. Affidavit in reply. You are filing it today.
I received the so-called notice number. And it was alleged that I revised the relevant record of rights and altered the records without prior permission to yourself. That 5/12/13, I said that please supply me the copies which you want to plan. Authority mirror, there are mirror, my mirror and directly mirror to take place. After what? Now after 7 days. They mirror without considering mirror, my prayer 2014 after mirror 1 year, they issued a charge. That my client suffered a severe attack. And then the punishment order was passed on account of his absence the 16th May, and the reduction of pay at 2 stages up to 2 stages lower in the current payment for a period of 2 years, that is the deposition. It is a reduction of pay up to 2 stages lower in current payment for a period of 2 years. That I take the punishment order, which is in violation of natural justice, and the original application was filed to the tribunal. During the pendency of this 2018 matters on 3rd May 2021, my client received a memorandum dated 3/5/21, whereby the disciplinary authority had issued a second show cause notice, cancelling the earlier one, that is 16/5/2018.
2014.
16/5/2018, the order of punishment was issued. I suffered a cerebral attack. After 3 years, my client, while during the pendency of his 2018 while out of the punishment, he received a memorandum 3/5/21, whereby the authority said the earlier order 16/5/2018 that was cancelled. And cancelling the earlier one, and the respondent first time supplied the inquiry report. My client submitted the respondent the inquiry report, and at the same time he made a representation for grant of promotion to him, which has been very denied to him. I made a further representation where I prayed for the grant of the MCAS benefit to him after completion of 25 years of service. The prayer for MCS benefit was forwarded, and the benefit has been extended. 18 punishment, 21 said the cancellation of the punishment. Inquiry report was submitted. I responded to the inquiry report. I made 2 distinct prayers, grant me promotions, and my entitlement of the completion of 25 years of service. I am entitled to the.
What is the date on which copy of inquiry report was served on you? 21 or 22? Yes, please. No, 3/5/21 is cancellation of the punishment. Oh, so by the same communication. So they cancelled the punishment and said we have missed this step. Now we are complying with this step. Then you gave your reply. So there is no action on the reply till date.
No. Meantime, what happened? I made 2 representations. One is for promotion, and is for extra benefit scheme after completion of 25 years. Now, that promotion was not granted. Again, I prefer original application, which is also pending. Then, 19th July, I received a punishment order 19th July by the Commissioner and Additional Chief Secretary. It says that the punishment of reduction of pay to 2 stages lower in current pay, banned for a period of 2 years, same punishment, and debarring of promotion for first period.
19 July which year?
2022, 19 July 2022, punishment or reduction of stages current payment for a period of 2 years, including dividing of promotion for such people.
You have only one thing you have not given us, the date of charge memo.
Charge memo.
Yes.
Sorry. 24 February 2014. Page 40. I will take the document. Nominal. After this, I questioned this order, and again I filed a way application in the 2022, which was registered as way 636 of 2022. Then in September 2022, after 2 months, the register of the Honorable Tribunal, after considering the feelings, then he directed us to serve the respondent, and on 10/11/2022, the matter appeared before the tribunal. 16th December, the tribunal was kind enough to take up our matter and did not pass any identity matter of state of the impugned order 19 July 2022. On 9 March 2023, again, this application was taken up for consideration, but we did not attain due to personal reasons. That was delayed. I came before your lordship's court, and the petition was disposed of on 27 March 2023 by holding, after taking adjournment of the next day, it is not open for the litigant. All back on the earlier order and following before the higher court, participating to be a case of refusal to pass the order and invite the attention of the higher court. Decide that therefore the order of high court did not appreciate the order. They will have until the next day. So I thought again, and then I came to high court that on the past day this was not done. Oh, it's no perception of self-defense under this. That is my argument. Because I will say the facts in the refuted when it is unprecedented, but it has to be said. That this application was taken up again after this order was passed on March 2023. On May 2022, after hearing that the tribunal refused to pass each order and again fixed the matter on non-counts. I again came before your lordship on July 2023. The matter was dismissed on merit. Therefore, did not interfere. Our application was again taken up on that date, 9th August, as it was scheduled. The departmental representative before the tribunal not by the departmental representative. After 4 months, 2024, 3rd January, the matter was fixed. On that date, again the government took time, extension of time, filing time. Then, 2023 August, the matter was taken up for consideration. We expressed our willingness to get motion as SRO 1, and accordingly, the original application was disposed of. July 2023, we received an order whereby the authority concerned withdraw the 25 years MCS benefit and sought to recover such benefit already disbursed after the session of the bill. This is the subject. 2014 charge sheet, 2021 order of punishment, accompanied by inquiry officer report. 2022 I prepared an application. Then I came for your lordship. The benefit was given to me. MCS benefit promotion could not be given. The punishment order was confirmed after giving response to the inquiry report. The 25 years completion of service, the MCS benefit became that was confirmed upon the that was which is the argument of the tribunal what way did the tribunal? Article 12/2024 impugned order. Article 12/2024 but that is not a page 101. for my loss. Whereas 101 I am waiting for my loss consideration. And whereas departmental proceeding was initiated against such and such, and whereas final order in respect of the same departmental proceeding was issued in the order dated 19/7/22, imposing a penalty for reduction of pay, two stages, lowering the current payment for a period of 2 years, with further direction that the reduction will have the effect of postponing the future of its pay as per Rule 8(4) of WBS 68 Rule 671. And whereas 25 years of NCS benefit was awarded to Sri Muhammad, effect from 5/10/2018, but he was not entitled to receive the benefits as criminal proceeding as well as departmental proceeding as against him were pending in the preceding time, and no approval was received from the administrative department for awarding the same in favor of the Sri Muhammad. Now therefore, the government is pleased to withdraw the 25 years awarded in favor of Sri Muhammad. So I will not. This is the include order question before the tribunal. The tribunal said order dated 13/12/24.
Ultimately, it is whether this 101 is sustainable or not. They say that it was not due to you because of the pendency of the criminal. Criminal and charge memo in the departmental inquiry, both. The criminal proceeding and the charge memo in the departmental inquiry. No, that is one of the ground. The other is submit the charge memo in the departmental proceeding.
Yes, 2014.
24/2/14.
Page 44. Page 44.
So therefore, whether this reason is sustainable or not, that is only.
Number 2, whether this concept from combination of 25 years of service inside whether you can equate it with the concept of my.
So where is the MCAS scheme? Let us see. That will.
Every time in central government and state government, because your lordship said very helpful because available on the website. State. So when here it is not, your lordship asks the legal advocate Mr. Basumande kindly produce the scheme. We could not secure this.
Where is the MCAS scheme? Because see, normally these schemes. Yes. What is it?
He said that one fragmented scheme is there in the reply, but that is not being put by the answer.
Because see, the eligibility and disqualification are both contained in the scheme.
That is why I am requesting my lord, kindly direction because she is in the custody.
You will be arguing it's not a promotion benefit. It is to ameliorate the stagnation. It will come as it is. They will say nonetheless it is a higher risk.
The tribunal was not confronted with this argument from the state side that why this concept are two different aspects. Number one. Number two, that according to the rule, because that is a special knowledge. The rule is there. It is not meant for the public. It was not on the website, and we cannot find it on the market. But the question is why it is fundamentally different from the other one, and why we are tapping into the conscience of the tribunal. The reasoning is that why the tribunal was swayed or persuaded by the submission of the state that is different. Because in one disciplinary matter, the lordship said, while we are dealing with the disciplinary judgment, after doing the prima facie of the the lordship has always insisted on the finding of the facts, where from the decision. Alright, where is the basis? It's a journey, it's a choice. So then kindly ask her, to produce a scheme. If I can ask that this is that there is no difference.
Where is the part of the scheme that you are reply which page?
But was not confident because I did not play.
This appears to be the scheme.
No, I don't know. There is a subsequent scheme. Thereafter, there are the government activities. 2009 scheme is there. 2012 or 30%.
No, but you have claimed the benefit. You must be knowing under which scheme you are claiming this benefit.
When I only say that after completion, the question of improving existing career scheme for the government employees as introduced in the finance department, such and such, has been further consideration for the government for some time past. The recommendation of the fourth paper have also been under examination of the state government, and after careful consideration, government is pleased to modify the existing such and such scheme government employees in the matter. Why I am telling your lordship that there may be a further modification, because I am quite sure, but subject to the availability of the scheme, 2009, 2019 Lupamiller was there. Division of pay analysis. So we are government possibly will I wish government employee has got benefit of only one promotion or advancement to a student from the above first scale. Before 25 years, you not getting further under the scheme, except exception of every successful competition. If the promotion or advancement to as mentioned in this law takes place before 23, you will take pass on competition.
So if it had been a promotion, would you have got it during pendency of the charge memo? Could not have. You could not have. You can pray for anything, but you will not get. Huh? The normal rule.
Page 9 of the reply, and I will show a document of the page 9. June 9.
Huh? 12th June. Oh, at the bottom.
Yes.
Yes.
This Miller, when the present Advocate General Miller was not Miller with the government Miller, he appeared sorry, it will undercoated turbine, WPSC 154 of 2014. Then the printer is
So the ad hoc promotion is not contingent upon the result in the proceeding. It has to be. So therefore, now in view of the fact that in this case, there is 22, punishment is 22. Then cancelled second.
2014, 7 years passed. There is not a single amendment or a muscular rule suggesting the lordship's that it is the petitioner who had contributed to the delay. Number two, I suffered a cerebral stroke. I informed the authority. Authority Miller realized its mistake, withdrew, but the conferment of that mistake is a completion. When Miller, I am still in service. My year of completion of 25 years cannot be obliterated or deleted from the records. The language is very clear. If I have completed 25 years, it is irrespective of the fact that whether it will be the same. Because
See, normally the time-bound promotion schemes, they come with a stipulation that the eligibility for regular promotion is required.
In 1918, it is perceived. I do not know. That is I'm very cautious. I'm very careful.
Is there any provision in this, the one which he has shown us?
Page 39. While on page 39, I wanted to show you last. Categorically say that disciplinary proceeding for the disciplinary to be initiated in the applicant in the year 2014 cannot be apart from promotion in view of memo number 12618, which says in the year the promotion should not be taken but disciplinary proceeding has continued for more than 3 years without the fault of the exam.
No, that's all right. That is what an ad hoc promotion is. But is it ad hoc promotion is to be regularized irrespective of result of the
The outcome of this process.
Correct.
Number two, Miller, that the question is Miller, that be I was not given and HCS very big. If HCS very big, I am saying that 2001, because 2019 Miller, I have come. You will find. So Miller kindly ask that the scheme also. Whether this scheme which
See page 29.
Yes.
Second paragraph, last sentence. Every movement of such higher scale of your reply. Last sentence. Now, in second paragraph, last sentence. Every movement of such higher scale. Second paragraph, last sentence.
Every movement of such higher scales will be subject to fulfilling
norms of promotion.
Yes. Now, subject to fulfilling the
norms of promotion. So, therefore, can you get a promotion when a charge memo has been served on you? KV Janki Raman.
1980 there is a clear answer. 1980 which I relied on. Then not in super can be asked to.
So, see, there's not an issue of ad hoc promotion now. Now there is a punishment. So there's no question of ad hoc promotion. Therefore, we are saying, how can you improve this circumstance? Now, if that punishment is set aside, upset in appeal or before the tribunal, then you may get. Otherwise, how can you get?
Whether this is synonymous that if I take the MCS 35, the promotion which was due to me, that was denied. 2014 to 2028 or 21.
No, that is for under a normal circumstance. For everyone, it is the same.
Particular 2014 is 2014 2018. After 4 years, they issued this order.
It's not the point. The point is once you have been punished, where is the question of continuing with an ad hoc benefit? Because at best you are getting an ad hoc benefit, even if not stated in so many terms. If there is a provision as has been relied upon or looked into by the coordinate bench, then that was an ad hoc benefit. It was good while it lasted. Now after the punishment, it cannot. You have no case once the punishment is awarded. Till such time, the punishment is interfered with or set aside. After punishment, ad hoc cannot continue.
The impugn order 101 amounts to withdrawal of the entire.
It has to. It has to. That's the whole concept of ad hoc. Where is that provision for ad hoc promotion? Without any provision in the rule.
Where you see confirmation promotion gets started here to page 10, the confirmation promotion efficiency part selection to the appointment of a government service for recruited service candidate to higher post should not be held up merely because inquiries are pending in the business function. This should be held up only when departmental procedural initiatives
Have been initiated. So as in your case, in 14 it was initiated. Yes.
that departmental proceeding government has taken decision thereof at the time of question confirmation of promotion is done. The confirmation of promotion efficiency by the crossing behavior permit of a government servant or recruitment service candidate to higher post should not be held up in cases where disciplinary proceedings have been started and have continued for more than 3 years, unless the delay in disposal of the victim is due to any delivery practice employed by the government employee concerned or due to proceedings in the court of law started at the instance of the last person. However, when confirmation, promotion, selection to higher post is allowed to anyone against when
On a provisional basis. That's what we are saying.
So that 2079 it was entitled. Because 2018 this was not given because whether it is a concept of correct justice, they must correct it.
Once the time is over, once the ad hoc period is over, what it means? After the punishment, whether now you have. It is from 23. Yes. Oh, you mean to say whatever benefit you have taken, you have taken?
Yes, that cannot be withdrawn.
So then show us some law to sustain this submission that a provisional benefit which is given contingent upon the conclusion of the inquiry, that you will be allowed to. No, we have seen your entitlement arises from this. This has rightly been pointed out by you. This has probably this is the basis on which you got the MCS. But now after the punishment, what case do you have? We can at best, you can, the best case scenario as far as we say right now, subject to any other law that you may show, is that you may claim this subject to result of the other OA or writ petition if you succeed, where you have challenged the punishment. Sorry. But prior to such punishment being set aside, you cannot get. No, he said he has challenged the punishment order.
No, he has.
Yes, madam, OA 636 of 22. 636 of 22. He has given a number. You should have been paying attention. Yes. Otherwise, what will remain in this? It will be pending for no use. This will not be. The brief facts arising for consideration are 120. Affidavit in reply is being filed, comma, and taken on record. And then 21.
I have done it from mistake. 20 and not.
Yes, so we saw his name in the order sheet, therefore we asked him.
This is due to old age.
No, no.
Now I'm
That submission is rejected. Anyone can commit mistakes. Yes, in the last order, instead of Mr. Day, you say Mr. Mukherjee.
sorry.
Yes. ASEAN. Oh, Karsen. Okay. Yes. Sorry.
Non-functional. I have specifically taken this point in my original application as well as in petition.
How will it function if you don't join?
My lord, I have joined.
Then it will become functional.
It is non-functional for several years. My lord, I am the only doctor. I am the superintendent. No patient. It is functional.
So instead of interfering with your transfer, we should direct more doctors be sent there.
My lord, no patients come across because the facility is, there is no facility also. It is a TB hospital. It is no facility because a better hospital has already been there, is already there. Now, my lord, I have another thing, my lord, that I am the joint secretary of the Doctors Forum.
Of the?
Of the Doctors Forum of Association of Doctors, my lord. Yes, there is in the pleadings also. My lord, during the RG incident, my association filed petitions before the Supreme Court also saying everything. My lord, your lordship knows the Supreme Court specifically stated that no precipitated action will be taken against them. After this, all this.
We don't know. You have to show us.
Yes, my lord.
Yes.
I am showing this. This is annex, my lord. Thirdly, my lord, there is a guideline, my lord, which shows that North Bengal, my lord, that is Karshiang or Darjeeling, this is Group A. I have already served more than 7 years there. From there, my lord, I was posted to Purbo Bardhaman, which is a super specialty hospital. From there, my lord, within 2 years, I was again posted to Karshiang after this Archikor incident, and after I, being the joint secretary, filed this special leave petition. This is my case, my lord. Now, if your lordship kindly come to the order of the tribunal, what the tribunal has been.
So where is the first, your sheet anchor is the order of the apex court.
My lord, this
is the order of the apex.
Yes, my lord. Page 52. Page 52, my lord, if your lordship kindly come. It starts from page 52.
Relevant at 55.
Relevant 55, my lord. Paragraph 3. No, not paragraph 3. No precipitated action.
No, no, तार आ गया।
No, no, तार आ गया।
Recently submitted. अच्छा। 64. Sorry, जी।
Page 64, man, and I'm grateful for it.
Because I have read that.
No, paragraph 9.
And 12 as well.
And 12, my lord.
Submission. Okay. 42. So release order is also. Page 44.
Yes, now show us whatever you want to show. What
Well,
else?
now kindly come to my to the order passed by the tribunal. This will your lordship will find after page, and this is the original has been given after page 66. Your lordship will find that. Right, I will be placing having heard, my lord, internal page. Internal page 3, my lord.
Where is the order of 19/3/25 transfer order?
Transfer order. Page 42, my lord.
What is DADHS? What is DADHS?
Deputy Assistant Director of Health. Correct.
Page 61. 61 was it? 61. Very good. Doctors. 25 collection. Estamos
Teachers.
Yes.
Now, Honorable says further that in administrative exigencies, I have been concerned. Well, I could have understood whether the hospital when I have been concerned, it is my requirement or ambition of the hospital is such, my transfer will facilitate the hospital for its good function. Now, when I kindly see, I have taken specific point that the hospital is just there is a building and materials, nobody is working, everywhere staff has been deputed, were employed there and this has been deputed to other hospitals. Whether through that specific allegation of we are opposition, we have created that page, maybe.
Yes. So how far a transfer order fulfills the administrative objective is to be examined in a judicial review.
Transfer order has been issued.
Yes.
Saying that because of administrative excellence.
Therefore, we are saying that has to be examined in a judicial review. They have to prove that it serves the administrative purpose or.
Under the register is based on lawsuit can intervene if on the face of the transfer order it can be shown that the utilization I have said today and the order my service my utilization service is not.
So therefore, substantially, you are saying that whether the transfer order fulfills an administrative objective or not is to be examined in a judicial review.
If that, if that.
We show us any judgment on this point. As long as we know the law is quite contrary, we are not required to go into such issues. We are not in the least required to go into such issues. A very thin line in respect of such matters, well established. If it is on a lower post, if it is vitiated by malefides. Basically, these two grounds.
Vitiated by malefides, if transfer order itself has been issued, the malafide nature, my lord, so as to punish you. And doing so, my lord.
That's why we said if it is on a lower post.
Yes.
If it is on lower post, then it may be a punishment.
And doing so, well, punish me, not necessarily in a lower post. Because, my lord, I say administrative, my lord, vindictive. And in my service, my lord, 12 times I have been served. 12 times. And all those I have given my details. This has been done specifically after the order of the Honorable Supreme Court.
That you have submitted, yes.
That
What is the meaning of the expression precipitate action? We will consider.
Secondly, I was previously posted in Calcutta.
That we have seen.
I have served 5 years.
You have been posted in Alipurdwar also. You have been posted in Darjeeling also. You have been posted in Kurseong also.
And my lord, from Darjeeling to Purva in Purva Bardhaman, while being serving as a within 2 years, I have been transferred to Kashmir. No, for my satisfaction, my lord, once your lordship will be kind enough to come to my reply.
Yes, we are looking at everything.
Reply page.
Yes.
Eighth line from the top, my lord, is stated in the figure, your lordship.
Yes.
On joining Darjeeling Hospital, petitioner found that the hospital has been shut down for many years. It grants no OPDs, no emergency ward, no for years, and the inpatient department, both day and female ward, has been locked down since 2018. Being the head of the institute, petitioner has to only face salary bills of 28 employees to the TDO who officiates at the GT headquarters. Out of those 28 employees, there was one medical officer, 2 pharmacists, 1 laboratory technician, 6 staff nurses, who all are deputed by the department to utilize their services elsewhere. That was the only medical officer under the payroll of Darjeeling PG Hospital who was detained at a block primary health center was transferred to a hospital in Gujarat. So there is no doctor posted at this hospital to treat anyone. Currently only 3 clerks, 1 Dholi, 1 electrician, 2 agent nurses, 2 duty staff, 1 sweeper and no technical staff is available in the hospital. Hospital only
49 সব নিয়ে এর হলো এটা নিয়ে না 4700 টাকা নিয়ে
the only duty of the petitioner is to sign on the salary terms missionary
bills and forward them to the DPO and GPA headquarters. On the contrary, the post of deputy CMO is Shubho is still lying vacant as on date. It will not be. This is my case. They are saying our transfer is issued on the ground that your administrative place where I was posted, it is still vacant. This is one specialty hospital, big hospital. This is kept vacant. On the contrary, I have been posted at somewhere where the hospital is closed. This closed by not the liability action of the state, and this has been done only after the order passed by the Supreme Court to takes action against me, since whether that is also in the Supreme Court order that joint forums of Dr. Mallard, I being the General Joint Secretary Mallard, I move this SLP Mallard against the state government. And Mallard, there is a guideline Mallard, if the tribunal has said it is not necessary upon the authorities to follow this guideline. Let's say Mallard, after 5 years you will be shifted to some other. Again, you cannot. And overall, I was not in 5 years.
You are referring to an order passed in a case of somebody else. Perhaps it's a suo motu.
Yes, suo motu, when we all examine method, you will finally come to a lot. 864. I can show you. 861 will not kindly come to the list of East is given here. Paragraph 4. During the course of hearing, a number of counsels have appeared on behalf of diverse stakeholders, including associations, resident and other documents. The counsel were represented in this process together with the parties for whom they are representing are set out below.
Yes.
Now, page 63, last one, joint platform of doctors presentation. I am the General Secretary of for 500, I was the General.
You are referring to which guideline? What was the guideline? Which guideline you are referring to? Regarding the spouse. Regarding the tenure.
Yes.
Yes.
The guidelines, sir. The relevant is that page 38 further for medical officers and general.
Yes. Capital B. Yes, yes, we have it for medical officers on general duty.
Capital B, my lord, Roman 5.
Yes.
Medical officers who have duty at least 6 years of service shall be posted in upper tier hospitals, these state general hospitals and sub-regional hospitals. However, on introduction of the new policy, there shall be medical officers and of the policy as laid down in 1 which shall be mandatory for them to serve in second-tier hospitals within the above section. However, since we have
categorize some areas from A to respect of Kushinagar district, such officer to work previously. Previous now be categorized shall be considered that India shall be for 5 years and not more than any category depends on the category of previous post. Such medical officer shall be transferred into another upper tier hospital after 5 years to another category. Another category. India is saying so whether from Darjeeling to Bardhaman baseline period. This guideline says after 5 years to some areas, not to again to Darjeeling or not Bengal to Bengal.
Very well. That's all. Yes.
But I'm good. One thing, indicators that the hospital is non-functional and the Supreme Court that vindictive. Those who are not in their opposition, they have said that they make no.
Alright, I did your lot. Start from where you have left. And you come to page 30. Roman 4B. Ethical officer working in category A. He is working in category A. May continue to serve the same area for another period of 3 years if they so desire and apply according to as to reach the MA branch of this department and DHS immediately after completion of 2 years of service at the existing place. However, medical officer opting when in A category may this area may be allowed to work in A category area beyond 6 years, subject to the condition that posting shall be made. Then, my lord, 5 he is referring to. These are, my lord, dependent on the exigencies. Now, his case was that husband and wife could be in the same place. Since 2013, he was in Bardhaman, in different places. And his wife was working in a school. There was no disruption. Now disruption has come.
His wife is a teacher and his children are studying in Calcutta.
But with regard to 2 things he has said, that Supreme Court has passed an order. If your lordship sees the Supreme Court
No,
order,
that he has not stated to the authorities. That he is saying for the first time in court. To the authorities, he has said about his wife, about his children, and then of course that the post where he has been transferred is a post for the ACMOH. It is not for a DADHS.
it's not group A.
Yes.
Well, it kindly come to opposition.
No, that we have seen. That we have seen. You have stated that yes. You have stated that it has been upgraded to a DADH post. And he's
next state itself.
yes, and then he continues to get the salary and all benefits of a DADH. So there is no lower post issue is involved. Secondly, he says third thing he says is that it is a 50-bedded hospital where hardly any patient is admitted.
He expects he is a competent officer, a medical officer. He will upgrade it.
Let's see.
This is for the interest of the hospital which has been done.
In his first response to the transfer, these are the only 3 issues that he have taken up. He has not said anything else. It is at page 43 of the writ petition.
Yes, yes. Unity.
Everything now in court, he is enlarging all the things, saying everything that can come to his mind.
Wife headmistress at Kolkata, disruption of family, and then he is protester of art.
Yes. And that ACMH, the bills are drawn by GTA, DADHS, the bills are paid by the state government. I have to go to the GTA, all these things, yes. Nothing about the Supreme Court order. Yes. Show us where you have said that at page 43 or 44. So, sir, when the court makes an observation, before you say no, please verify. Why we will say something if after reading a document, if it is there? You can say a no without thinking to what he says, but not when we make an observation. No, you have not taken that. You have said that you have taken these three grounds basically. That it is transferred to a lower post. Secondly, you have said there is no optimum utilization of your capability. No, on the date you have sent the representation, it was already there because just next day after the transfer they have done it.
Yes. Yes.
See, what is this date of your representation? Is 21st March.
That I am submitting on instruction that criteria is good because that is why I did not look up this point when I before your lord can go on. I said that.
Yes, you have not taken up. Yes, you have not taken up. Where is the judgment, sir?
That judgment of.
The applicability of guidelines, how it is.
Yes, I have got it.
So you show it, we'll pass the order here itself. You show it to us on the next day. You give him a copy. The arguments have been advanced on behalf of the parties to stop due to paucity of time today. We adjourn the matter for